My matter is
Exit from interim order, my lord.
Lordship 23rd. Lordship, my matter is 23rd is expiring.
Put on 22nd to be mentioned.
My lord, may I permit to mention on matter for
Okay.
leave, my lord? My senior Mr. Dibyendu appearing for
Item
lordship,
number
my lord.
47 of the today's list. This is an extreme urgent matter. And I cannot wait that because my lorry with loaded kaju nuts has been stopped by the marketing committee of Malda. My delivery date is fixed on 23rd. I have to deliver it, otherwise I will get more loss. But kindly fix on the Monday at the top.
Huh?
Kindly fix Monday at the top.
They at the top. So why your vehicle has been stopped?
Hello?
Why your vehicle is stopped?
Account of levy. This is the subject matter of challenge.
Have you approached the authority?
Yes.
What the authority says?
I have approached the authority. A requisition was moved. This court passed an order directing the authority, marketing committee, to decide this case because I have been covered by the section of the Agricultural Police Act. But in spite of that, the order was passed. Now you have to give the levy. That is subject matter of challenge.
You have a road challan?
Yes, all these.
All these. Okay.
Malad,
My lord, may I permit to mention one?
Malad, may I permit to mention one matter, Malad?
Urgent motion.
Malad.
47 item in the hearing urgent motion.
Mention a matter, my
But
lord,
but
has passed
that will be
order
top.
on 15th of December for extension of interim order.
Okay.
But when we get the order, my lord, we find, my lord, your lordship's order has not stood extended, but there is only a recording that a modification which is done by the appeal court, my lord, that is only there. But your
Lord, I believe, Lord, I believe that Mr. Rai is mentioning without notice to us.
No,
If it is that walk-up matter, he should first notify us and then mention. Mr. Rai, please notify us then mention. I am fortunately here to oppose. Do not mention in our absence. Please do not mention in our absence. Please give notice and mention.
Urgent motion.
Please give notice and mention.
Malad, may I permit to mention matter, Malad, under compelling circumstances?
If it is the walk-up matter, please give notice and mention.
Mr. Chakravarti, let it come on Monday as to be mentioned.
Lord, there should be a
I
notice
am
to
not
us.
passing
Lord.
it. Okay.
There should be a notice to us.
My lord, may I permit to mention matter?
And what Mr. Rai is saying, the same
47
submission was made by
under the
them.
heading urgent motion. So let it be top. Otherwise, if it is not taken on Monday,
Not top. That's why I'm
Malad,
telling
may
all
I-
persons are mentioning the matter. All top with the 47 is the
under
top.
the heading urgent motion.
Maybe.
But
Yes.
kindly take it up or top at the Monday.
Malad, may I permit to mention matter, Malad?
You do one thing. You come here and whatever the
No, I will be
heading.
get more loss.
So that's why all persons are having urgent matter.
Date is
That's
fixed on 23rd.
Yes.
Otherwise, I have not troubled your lordship.
Malad,
What happened in this matter, my lord? Serial number 70, 71 and 64.
no urgent, no mention. Call the list.
Lord,
The advocates,
I was waiting.
if the advocates are not courtesy, they are wanted to mention all along. No mentioning. Yes.
Kindly, my
Mr.
lord. Kindly, my
My
lord.
lord, under company,
Kindly, my lord.
No.
under company
First you go and
circumstances.
think about what is the
We-
protocol, how it should
My lord,
be
we
mentioned.
should not have done this,
before
my lord.
the-
We should not have done this, my lord.
No, I will not take any matter till 1st or 2nd of January.
My lord,
I will not take any urgent motion due to the attitude of the bar. A bar is not having efficacy. How the matter is to be mentioned.
my lord, let us have him mentioning upon seniority
Okay.
basis, my lord. My lord, kindly, my lord.
Let the bar take the lesson from this court.
Kindly, my lord.
Just
My
put the
lord.
matter.
Kindly, my lord, do not finalize the
Lord,
litigation.
kindly have some mercy on us.
My
You
lord,
all
kindly.
persons are senior. You don't know how to mention the
My
matter.
lord, kindly, my lord, senior friends will be there, my lord. Let us mention chronologically at the ascending order, my lord. Kindly.
2 persons are mentioning. 2 persons are mentioning what the court. Wow.
No, we should not have done this, my lord. Kindly bears with us, my lord. Kindly, my lord. Seniority.
Only to mention,
I
my lord.
am warning the bar. If any time one advocate is mentioning the matter, if other advocate will mention the matter, I will not take any of the mention.
No,
Yes, my lord.
take note of it, my lord. Kindly.
Please maintain the decorum of the court.
My lord, under compelling circumstances, my lord, I am
Yes.
mentioning.
I will not take mentioning by online. Which one?
My gas goes by brine. It was renewed till, my lord, September 2025. We have applied within time. We have given notice without any hearing, without anything. The gas bank license has not been renewed, and it is the recall has been rejected. But 54 people are involved. They depend on the gas, my lord. Very urgent.
So if the authority has taken, you might have been violated any
No, no, no reason.
So why it is cancelled?
No reason.
No reason.
No reason.
So when you file the writ application,
File and serve.
Hmm.
You do that in 22nd, but according to the list, kindly some urgency, because otherwise, kindly make it an urgent portion of it.
22nd. Yes.
Doctor's choice under which I was saying about cooking oil, saying that this is a deceptive formula and asking for appropriate direction on the food safety.
Yes.
Can the authority to take action? On the day of very last week, the authority came and gave an improvement under section 22 of the act saying that I have to take appropriate measure. By that notice, that is dated 15 December, they essentially asked me to stop using my mark. So I cannot use my mark anymore. It is a miscompelling circumstance, I am filing a writ petition and hand up the number if the lordship kindly conclude because the business will come to a halt. I have inventory I cannot sell, and my lord, penal action will be instituted against this.
No, the letter says you cannot use the marker of the doctor choice. Now, nothing the business. You cannot use the marker of the doctor and the stethoscope. At your stage.
Two prior notices of the same nature have been given to me. Prior, they had only said disclaimer is sufficient. I have disclaimed. And now, there is no change in circumstance, there is no order, without any further action, without any intervening circumstance. They give a fresh notice. They say now you cannot use the market. Simply said that because the petition is filed.
Correct. On that day, they have produced the notice, but they have already taken steps for.
I have looking for stay of that notice because that will bring my business to a grinding halt. I cannot carry on any business under that mark. I have been using that mark for decades.
What
But
can
I have inventory under that mark.
at this last session? What can be done when the matter is fixed?
That petition is effective 27th of January. The notice is of 15th December, my lord. I have come within 4 days. Kindly, my lord, keep it on Tuesday.
How? I don't know. I can fix, but I don't know it will be taken up for hearing.
Just try and my lord, because in extreme urgency, my business will come to a halt. That is the difficulty.
Have you issued the notice?
Overnight, they want to stay the use of my money, effectively cancelling my funds.
Have you issued the notice?
My lord, we will serve the writ petition. I am praying for
Have you served the notice to them? Mentioning notice was issued.
Yes.
To whom?
I am praying for leave under section 80 of the CC. My lord, with leave to serve the advocate who was appearing on behalf of.
So you have not filed the writ also.
My lord, today we are in the process of filing in the course of the day, I will hand up the number. Because the notice is only of 15, today we are on 19. I have moved as expeditiously as possible. 16 part of their furnished a copy of the notice.
Okay, 23rd Correct. Allowed to file. Be listed as urgent motion on 23rd.
I will hand up the number to you.
Yes.
Or may I have your lordship's kind leave to mention this is a tender matter, my lord. The petitioner has participated in the tender proceeding, my lord, and my lord, due to frolicsome ground of having not my lord, qualifying with regard to the credentials, the technical bid has been my lord, rejected. The petitioner fulfills all, not only all, my lord, he is the having every credentials and more than others. My lord, I have appended those credentials before your lordships, my lord. Any day the financial bid will be open, my lord. Kindly takes up this matter, my lord, any day convenient to your lordships court, preferably on Monday, my lord. I shall.
What happened to the technical bid?
My lord, technical bid has been rejected. My technical bid has been rejected, although I am having the much more credentials than any other participants in the tender process. I shall so demonstrate from your lordship's brief, my lord. My lord, kindly takes up, my lord, any day convenient to your lordships, preferably.
Come after vacation.
My lord, any day financial bid will be open, my lord. This
can be done.
writ petition will be infractious.
You mentioned the matter in the vacation.
My lord, kindly, my lord, grants me, my lord, time so that I can have it moved before your lordship's court any day on Monday or Tuesday, my lord. Any day this financial.
I will fix, but I am not giving.
Kindly, I shall.
Because see,
urgent
matter.
I understand, my lord. My lord, I shall take my chance.
Reach by 23.
My lord, I shall take my chance, my lord, before your lordship's court. Kindly, my lord, allows me to file with short service, my lord.
File
Great.
22nd.
Grateful.
Yes.
May I mention for extension of interim is expiring today. I had mentioned the matter 11th of December and therefore yesterday, Lordship.
It is not listed as to be mentioned.
No, Lordship. I've been informed that.
Which matter?
Lordship,
It is not in the list.
No, Lordship.
You need.
Lordship, I've been informed that the file cannot be found.
File cannot be found. What can be done then?
Lordship, the interim is expiring today only.
Where is the interim order? It is of disco jurisdiction determination.
Yes, Lordship. Lordship, a similar matter, I have ordered Lordship, I had mentioned two matters. One of the matters came up yesterday as item number 4, Lordship. But this matter did not come up. Lordship.
Who's for the other side?
Lordship, Learned Counsel Mr. Wasim Ahmed appears for the
Have you
state.
issued the notice?
Yes, I had issued the notice yesterday for yesterday's mentioning, not for today's, Lordship.
तो फिर
If your Lordship allows today's mentioning, I will.
इसको एक काम करो, तो टू बी मेंशन एक सप्लीमेंट्री लिस्ट निकालो 2 बजे, इसको टू बी मेंशन में रखो, एक्सटेंशन ऑफ एंट्री मॉडल, और ये दो मैटर है, ये दो मैटर को अर्जेंट मोशन में 2 बजे, और नीचे लिखा है अर्जेंट मोशन 2 बजे, ठीक है? सप्लीमेंट्री लिस्ट निकालो.
My lord, may I be
Issue notice supplementary list will come as a to be mentioned.
Grateful.
My lord, may I be permitted to mention one matter? That this matter is of great urgency because, my lord, your lordship knows there is this now cyber fraud is a very.
What is the urgency? Tell
My lord, my entire bank account has been
Okay, come
frozen.
at 2.
My lord, may I permit to
2nd January.
may I permit to mention one matter for extension of interim order? It's ending before the end of December, my lord. I have mentioned already.
Where is the order?
I have already mentioned before your lordship on Tuesday, my lord.
Where is the order of interim or last order?
Right. I have on earlier occasion I have submitted, my lord.
Yes, next. Yes.
West Bengal Police Recruitment Board 2024, my lord.
Ah.
And this is a selection process of 2024. And at that time, they have their EWS certificate. But the written examination is conducted on, my lord, 2025. At that time, the authority seeking 2025 EWS. In the meantime, the petitioners cast are Swadgop. So the OBC list they have included, so that the authority refused to give their EWS certificate, my lord. But a similar matter is my lord. Leave was granted by this honorable court and fix this matter on Tuesday, my lord. My lord, kindly grant me leave and fix
Which
this
matter Tuesday it is fixed? Which matter?
Similar matter, my lord.
What is the number? What is the number?
To
उसको लेके ट्यूसडे रखो अर्जेंट मोशन में. Yes.
Lordship, I'm praying for leave in this.
Yes.
Lordship, I'm praying for leave in this matter. Lordship, the BDO has been issued a work order to BDO issue a work order to make a construction to wall in front of SDO office, Lordship. And that road, Lordship, we all are 57 villagers, Lordship, are obstructed for that road only. When they're going to the emergency purpose, Lordship, to the hospital, to the everywhere, Lordship, my egress and ingress will be, Lordship, obstructed. And they have inspection yesterday.
Go to the civil court. Yes.
May I have my lord's leave, my lord? I've been led by Mr. Chakraborty, who is appearing online.
Lord, may I mention this, Lord? I know your lordship has asked me, so
I will not allow online. I will not allow online. If you have urgency, you come to the
My lord, the urgency is that, my lord,
The
urgency is that the tender opening date is today, my lord, and the financial bid will be opened any day, my lord. Despite there be a interim order whereby the show cause notice was stayed by your lordship, and my lord, they had intentionally, purposefully blocked my ID so that I cannot submit my bid, my lord. Intention, my lord. Kindly grant me leave so that I can file this matter and move it, my lord, on Monday, my lord. Kindly, my lord.
I don't know.
When a financial bid will be open, my lord, I will lose
I
my.
don't know. It will be taken. Allow karo Monday रखो.
lordship, may I be
Grateful, lordship.
Yes.
Monday. Monday, below. Leave the Monday below.
And now the other joint court is not cooperating with me, but I cannot submit my right. All I'm listening, my document.
Take microphone.
All I'm wishing, my if your lordship may kindly keep it under heading urgent motion, my lord, on Monday.
What is the urgency?
My lord, the urgency is, my lord, the other joint holders, my lord, they're trying to deprive my proportionate share of rights, my lord, over the fixed deposit accounts, my lord. And even some of the amounts, my lord, has already been siphoned up. As a matter of fact, my lord, if I cannot obtain an interim order, my lord, then they will actually defalcate the entire funds, my lord, and they will utilize it for their own use, my lord. I have my proportionate share over this fixed deposit accounts, my lord, because one of the joint holders is my husband, my lord. And since one of the joint holders is my husband, my lord, your lordship knows it, my lord. There are several Supreme Court judgments, my lord, which clearly says, my lord, that the other joint holders is just a custodian of the other share of that particular amount. Now, if they try to utilize the entire amount, my lord, then my entire REIT application becomes infructuous, my lord. All I'm wishing, my lord, if your lordship may kindly keeps it under the heading urgent motion, my lord, on Monday, my lord.
My lord, may I be permitted to mention one matter? Item number 2 to 6 of the today's list, my lord. A high voltage transformers was.
What is the urgency? Tell me.
My lord, a high voltage transformer.
Okay, no. Yes.
Your Lordship, lease has been granted to me by Zilla Parishad, and according the SDO has cancelled my lease in spite of there being a lease, and I have preferred an appeal before the DM from under the West Bengal Highway Act. That appeal is not being heard. Meantime, I have been given a notice that I shall be evicted. I was seeking leave under
When the date is fixed for eviction?
eviction, Your Lordship, on 16th of December, the demarcation was fixed. I have filed the writ application, affirmed it yesterday, Your Lordship. So any day before the vacations, they may.
I don't know. 23 go rakho.
Sincerely
Permitted
obliged.
to mention a matter, Your Lordship. It is appearing in today's list as item number 72. The urgency.
23 as urgent motion.
Lordship, the urgency is that the president is
23rd.
creating anarchy in the
23rd
residential
urgent
complex,
motion.
Lordship, by demanding extra 20 lakh for a defective water treatment plant, Your Lordship, with using industries. And the meeting has been scheduled on 21st of December, Your Lordship. If it will not taken, then it will become a petition. Will
Come after vacation.
My lord, craving leave to mention one matter. My lords, these are Incentive Revocation Act matter which were taken on 16th on Tuesday. My lords, I'm mentioning matters which are on the appellate side. My lords have directed that all the matters will be tagged together. Original.
After vacation, it will be taken.
My lord, I mention a matter, my lord, for extension of time to file my affidavit in opposition. My lord would recall this is the jute matters matter, my lord, where the sugar mills, my lord, had impeded, my lord. They had filed an application, my lord. Direction was upon me to file my affidavit in opposition by December 12th, my lord. Out of days for my lord, 5 days. And my lord, I have already served my learned friends on the other side.
Have you served?
Yes, my lord.
Okay, come on. When the date is fixed.
My lord, that's on Monday, my lord.
Okay, come on that day.
With regard to item number 129, it is for extreme urgency, my lord.
What's the urgency?
My lord, the money is being withheld by the bank, my lord, without any kind
Okay,
of criminal action.
come in the month of
My
January.
lord, your
Yes, call the
lordship
list.
directed the video.
591, Your Lordship, and a minor girl of 15 or 17 years is in home because they were caught hold in a hotel, Your Lordship. Those are minor girls under POSCO, so they are under the home since August 2025, Your Lordship.
Where are they? Not these victim girls.
They are in the home, Your Lordship.
So now what do you want?
Barakpur home. Their parents have filed this application so that they may be released, Your Lordship.
So you file, go to the trial court. What the trial court do? Have you filed an application before the trial court? File the application before the trial court. Yes, call the list. File the application. Thank you. The revision is dismissed. The petition is directed to surrender before the London magistrate within 2 weeks from date. Next. Yes.
I'm led by Mr. Near for the deposit.
I'm appearing for the state respondent lordship.
I directed the respondents to allow the petitioner to continue the work as consular, and if you wanted to initiate any proceeding, you initiate any proceeding in accordance with law.
Appearing for MSTC limits lordship.
Date petition dismissed. Yes.
I brought these two petitions, my lord, Cran 5 and Cran 6 before your lordship.
Yes.
My lord, one is for extension, simpliciter extension.
Item number 456.
Item
Item number 4 CRAN 5 is for expansion of the name of one petitioner who has expired, and CRAN 6 is for extension of interim order.
Mother would kindly take up 10-6 first, my lord, extension of interim order. The last
Who filed the CAN 5?
CAN 5 was filed by the other petitioner, the son of the petitioner who has expired. Petitioner number 2, before your lordship. He has filed it. He has filed both the applications since petitioner number 1 is no longer there. My lord would find the death certificate annexed at page 6.
In which? CAN number?
In CRAN 5.
CAN 5
is the
expunge the name of the petition number 1.
My lord. Page 6 is the death certificate.
Who is the petition number 1?
My lord, Vinodi Lal Agarwal, my lord would find the...
What is the application, this writ petition?
My lord, the original criminal division. My lord, it is against conviction under the Prevention of Adulteration Act in a case which was initiated in 2011 when it had already been replaced by Food Safety Act. That act was no longer there.
So petition number 1 died.
Petition number 1 has expired, my lord, very recently on 28th of October 2025. My lord would find that at page 6 of CRAN 5.
28th of October.
28th of October. Date of death.
Where is the date of death?
My lord, on the left side, second
yes. Which was the state?
We appear for the state, my lord.
So I am allowing this.
My lord, may allow, my lord, but then our we have an arguable point that the notification that he is relying on
5 and 6 with regard
for extension, my lord would find the last order of restoration and stay, my lord, at page 9.
Page 9. Restoration was done on?
Restoration was done on 25th of September 2025, just before the Durga Puja vacations, my lord.
Where is the order of
para 12, my lord, page 10, para 12.
The order of sentence and suspension until the December 2025 until further order. So with regard to the 6, what is your submission?
My lord, may extend it for the time being, my lord.
I am extending and I am fixing a date for hearing of the divisional application. So the trial court record has come.
That was, my lord, not required.
Not required. You have a you have enclosed all the evidence of the parties.
My lord,
evidence and exhibits of the parties.
Not
how many witnesses have been examined?
My lord, let it come. Let it be called for, my lord. The LCR.
My lord, may call.
The petitioner has filed an application being CAN 5 of 2025, praying for expunging the name of the petitioner number 1, namely Vinodi Lal Agarwal, on the ground that the petitioner number 1 died on 28th of October 2025 during the pendency of the revisional application. Consider the submission made by the counsel for the petitioner. Peruse the death certificate. Name of the petitioner number 1, namely Vinodi Lal Agarwal, is deleted from the first title of the CRR number 1102 of 2014. The petition is directed to take appropriate step for deletion of the name of the petitioner from the cause title and to serve the amended copy of the cause title to the state respondent. CAN number 5 is disposed of. The petitioner has also filed an application being CAN 6 of 2025, praying for extension of the interim order. He submits that by an order dated 25th of September 2025, this court has restored the criminal revision application and also suspended the sentence until till the end of December 2025 or until further order, whichever is earlier. He submits that accordingly prays for extension of interim order. At the learned counsel for the parties, the interim order passed by this court dated 25th of September 2025 is extended till कौन सा डेट खाली है 2 बजे? अरे अपना दिमाग से मत बोलो, डायरी से देखो. On 27th January 2025 at 2 p.m. as a specially fixed matter. Interim order is extended till 27th of January 2026. The department is directed to call for the trial court record in connection with CR case number 4. Trial court record number in connection with 02D of 2011. Where is that judgment?
Well, the judgment is at page 30, well, 30 of the criminal revisional application. Case number 02B of 2011.
30.
30 of the criminal revisional. Yeah.
Where is the judgment? CR case number 2 with capital D of 2011 within bracket Kolkata Municipal Corporation through the food inspector versus Binodi Lal Agrawal and another. By the next date fix. Grand number this was. Next. For extension of interim order.
Your Lordship, I'm not standing in the way of extension, Your Lordship, but there was a direction by the erstwhile bench taking up the matter that they need to have consent to operate. They are all hoteliers near the seaside, Your Lordship, Mandarmani area. So they do not have valid, from the documents, it is apparent they do not have valid consent to operate and consent to establish. Your Lordship, any day, Your Lordship, in January, the matter may be fixed for hearing.
Affidavit filed.
Affidavits,
ready
Lordship,
for
there are a
hearing, Your
number of
Lordship.
respondents. The Central Pollution Control Board has filed an affidavit
Lordship, all affidavits have been filed.
from your end. Lordship, your Lordship is hearing 5 matters on the same point of law, that is the coastal regulation zone. 3 of the matters appeared yesterday, which your Lordship has already extended the interim order. So there are 5 matters tagged along. In fact, this matter was also tagged along with this with the matters that your Lordship has taken up yesterday.
When the matter is fixed?
Your Lordship,
Yesterday's matter is fixed on?
Lordship, I'm not aware. I'll take instructions and inform your Lordships.
Separately, because the
Lordship, same point, kindly extends the interim order and
Yes,
fixes it for hearing.
I beg to appear for the State Pollution Control Board led by Mr. Bian. We are yet to file our affidavit in this matter, my lord.
Filed.
Not filed, my lord.
You are the main authority.
West Bengal Pollution Control
You are
Board.
the main authority. Then
Lordship, I'll file.
petitioner is enjoying the interim order. You are not filed the affidavit. The
But in
Lordship,
similar
there are
matters
many
probably
points
has been
that
filed,
will
but
be
in this
mentioned.
matter it has not been filed.
On the prayer made by the counsel for the petitioner for extension of the interim order. Counsel for the Pollution Control Board prays for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks after winter vacation. Reply, if any, there to be filed within a week thereafter. Full stop. It is submitted that the other respondents have already filed affidavit in opposition. Accordingly, this is the matter on 3rd February 2026 at 2 p.m. for as a specially fixed matter.
Great, your Lordship.
Interim order is extended till 3rd February 2026 or until further order, whichever is earlier.
Great, your Lordship.
Next.
My lord, I am appearing for the petitioner, my lord. This is appearing at my expense.
Union Bank.
My lord, it's expiring today. The interim order was first passed on 22nd May 2024.
My lord,
then
I am
later
my
extended.
lord, I am filing affidavit in opposition, my lord.
My lord, may I just indicate? My lord, the interim order is dated 22nd May 2024. They have filed their affidavit in opposition in April this year.
My lord, the fact is that I have served the copy 11/4/25. Till date, they have not filed reply and they are enjoying interim order. My lord, actually last occasion, I am filing affidavit in
It is
opposition.
being filed
My
today.
lord,
They have been served.
last occasion when the matter was heard and it was extended without intimating the bank or me, my lord, matter has been mentioned and it has been
What
extended.
you want?
My lord,
My
I am
lord,
seeking. My lord, I
interim
am
order
the.
should not be extended.
My lord, I am.
And our date may be fixed for hearing. My lord, I am filing affidavit in opposition.
Matter is listed as to be mentioned on the prayer made by the counsel for the petitioner for extension of interim order. Counsel for the defend number, respond number.
I am for Union Bank of India.
Respondent Union Bank of India has filed affidavit in opposition after serving the copy to the London counsel for the petitioner and submit that the opposition is served upon the petitioner in the month of April 2025.
Yes, my lord, 11/4/25.
But till date, the petitioner has not used the reply, and as such, he objected for extension of interim order and praying for hearing the matter on merit. At the learned counsel for the respective parties, this court find that the matter is listed as to be mentioned only for the purpose of extension of the interim order, and this court also find that the petitioner is already enjoying the interim order of single law. Accordingly, for the interest of justice, the interim order is extended till 4th of February 2025, 2026 or until further order, whichever is earlier. List the matter on 4th February 2 p.m. for hearing. In the meantime, the petition is liberty to file the reply to the
I'm grateful, my lord.
My lord, my lord, I have filed affidavit in opposition. It may be recorded.
Been recorded. Grateful, my lord.
I appear for the respondents.
Lord, I appear for the petitioner. But my video is disabled
The
by,
interim
I
order
don't
is
know.
since July 2024. Affidavits are complete and my vacating application is pending since September.
My lord may fix the writ
Any
petition
date,
anytime,
yeah.
Lord.
affidavit with regard to the vacating application or
Writ petition, my lord. Writ petition.
Writ petition.
It's a very thin vacating application, no new document. Main matter is affidavits are complete, that should suffice.
So I'm fixing
Lord,
for
Any date.
my
any
lord,
date.
kindly,
Extended and
Any day.
kindly extend the interim order, fix any day as per your lordship's convenience, Lord, we will argue it.
the same. The matter is listed as to be mentioned on the prayer made by the counsel for the petition for extension of the interim order. Police counsel for the respondent submit that the pleadings have been completed. The matter can be heard on merit. At the learned counsel for the parties, the interim order extended till 5th of February 2026 or until further order, whichever is earlier. List the matter on 5th February as at 2 p.m. for hearing as a specially fixed matter.
But I'm grateful to lordships.
Next.
Eight, I appear for the respondent bank. My lord, I appear for the petitioner. My lord, this is a matter, lordship, where there was a settlement. And there was a settlement, and Mr. Probal Mukherjee was appearing yesterday, lordship. A submission was made that we have not been following the OTS to oppose the extension of interim order. Lordship, I have taken instructions. My lord, may I indicate what happened?
Yes, what is the instruction? Settled?
No, my lord. They have failed to pay they have paid the first installment.
Second, one
second,
crore,
they have
2
to
crore not paid.
No.
Well,
My lord, that is incorrect. I've got the documents. I've got the bank's letter. My lord, I've got the bank's letter. May I place the letter and I'll explain in a minute what has happened.
give the copy, give the copy.
But they have the, I don't think, they have the letter, lordship. My lord, what happened was, on 30th of August, I was supposed to pay 5 lakhs as per the settlement. Now, my lord, thereafter, the directors approached for modification of the terms. There was confusion regarding whether 2 of my directors who are in Bombay, whether their consent is enough. By the time this dispute was sorted, the date for making the payment of 2.2 crore was already over on 30th November. Because the bank came back with the instruction that no, your directors based in Calcutta will also have to give their consent and they have to execute a debt settlement agreement. Accordingly, by this letter, lordship, it's been rescheduled. Lordship will see page 2, the last paragraph. So now there's a new term.
So you have paid the 81 lakhs.
But no, that is 31st December. They have agreed to this reschedulement, rescheduling, provided we pay an extra amount of interest from 1st December, which we've agreed to. So therefore, there is nothing outstanding. There's no failure on our part as on date. It's the communication which took time, which is why the 2.2 crore wasn't remitted. And that's explained also. If Lordship sees the preceding paragraphs, it's explained.
Yes, Mr. Mukherjee.
Lord, your Lordship will kindly see, Lord, they are asking for extension of the interim order. Lord, the second installment according to the Lord OTS has failed.
My Lord, it has
on
not.
the 30th of November. Lord.
Yes.
Now your Lordship will kindly see, Lord, the letter dated 5th of December, wherein my client had stated that in accordingly, my lord, the last two
Yes,
paragraphs,
I am
that
there.
accordingly, in order to keep the OTS alive, you are hereby instructed to remit the balance OTS outstanding amount and delay period interest as follows. There were rupees 81 lakhs to be remitted on or before 31st. Then we have the balance of 5,39,000. But they say that they have already remitted that 5 lakhs on 31st of August according to the OTS proposal.
No, 5 crore 39 by 20,
What is
28
balance
February.
is? Balance is 6 crore 20 lakhs.
Correct.
B and C added together. Then the B and C is outstanding as on date 30th of November 2025. Then it says that 81 lakhs to be paid by 31st of December. And the balance of 5,39,000 by 28th of February 2026 and the interest. So if my learned friend pays 81 lakhs by 31st, then only the interim order can be extended. That is my prayer.
So 31st this so because 31st
December has not yet come.
But
I am
if it doesn't,
I am fixing on 5th on 5th of January. I am extending the 5th of
it
January.
will be monthly list, not made be on 6th.
6th, no, I will be in as a to be mentioned matter. Let me see whether they are paying.
Lordship, kindly till that time.
Till I am
Yes,
extending.
kindly see whether their
Correct.
conduct. I am interested in money, not their property.
That's why the 31st December he has to pay. So I am extending till 6th of January.
Lordship.
And matter let the matter appear on.
Lordship, we are agreeable to that. We are agreeable.
So this court is executing the bank's.
I'm appealing for the Reserve Bank. May I have a copy of this letter? Settlement.
Give copy to the Reserve Bank of India so that they can. The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner for extension of the interim order. Full stop. Counsel for the petitioner has handed over a communication made by the South Indian Bank to the petitioner dated 5th of December 2025, wherein a further settlement was arrived between the parties. And as per the said settlement, the petitioner has to pay the balance total amount of rupees 6.20 crore, out of which 81 lakhs is to be paid by the petitioner on 31st of December 2025, and the balance amount of rupees 5 crore 39 lakhs to be paid by 28th of February 2026. In the said letter, it is further clarified that the further delay period interest at the rate of 10.25% calculated on the balance OTS outstanding of rupees 6.2 crore as on 13 November 2025 till the remittance of the total amount. Considering the communication of the bank, the interim order is extended till 6th of January 2026 or until further order, whichever is earlier. List the matter on 6th of January under the same heading.
Agreed.
My lord, may I make just one prayer, Lordship? Could it be extended till that Friday? Because 6th Lordship is keeping the matter, just in case, Lordship, just 2-3 days more.
No problem. This court is
Grateful, Lordship.
And
Grateful.
communication
pay, there is
dated
no
5th
need of an
December.
interim.
You kept the record. 5th of December. Yes,
Grateful to you.
item number 14 क्यों 11 बजे.
Your Lordship, Mr. Bhattacharya, learned senior
No,
advocate.
my
On all.
apologies, my lord, for appearing virtually, my lord.
Yes.
No, my lord, pursuant to your lordship's order passed yesterday, where we had responded to the queries. Thereafter, my lord, I had mentioned the matter also, my lord, at the time of rising. We had sent a further mail also.
Yes.
My lord, in terms of para 8 of my lord solemn order passed yesterday,
yes,
my lord was pleased to direct that considering the above, this court directs the petitioner to immediately by 3 p.m. submit the information to the concerned police officer. And if the information is received by the concerned police officer, the same may be forwarded to the subdivisional officer for taking appropriate decision immediately. No, my lord, we had done it, my lord. Now they received it. Despite receiving, my lord, what they have done is, my lord, I have affirmed another supplementary affidavit. Ms. Dotto, kindly hand over
Filing the
the
supplementary.
affidavit to his lordship.
Thank you.
But page page 9, my lord, is our response.
Yes.
Page 9 is our response. We had responded, my lord, categorically to the queries raised therein, my lord,
Yes.
pursuant to my lord's direction.
Yes.
Now, what they did was, my lord, instead of forwarding it to the SDO, again at around, my lord, 4 minutes past 5 o'clock, my lord, kindly takes page 12.
Yes.
They have once again sent another mail, the police. Now, in the guise of seeking clarification, again, my lord, certain fresh information has been sought for. My lord, may kindly, my lord, take this document, my lord, and appreciate the nature of information, my lord, that they are seeking, my lord. This is nothing but, my lord, a ploy to, my lord, deprive the petitioner from having the rally today, my lord. It's scheduled today at 2 o'clock, my lord, from 2 to
Yes.
6, my lord.
Yes.
Now, my lord, these are the queries. We had provided the number of dignitaries because they asked if, my lord, kindly compares it, my lord, with the document annexed to the last supplementary affidavit, my lord. That was the last query to which we responded, my lord. So they had required the details of the, yes, they say, please provide the stage dimension as well as the number and details of dignitaries who will be on the dais along with the protectee. So we had furnished the information that it will be the office bearers from the organizational district and the local political leaders, totaling to 20 in number, 20 people with the security personnel of the protectee. Now they are saying that no, we have to provide the name, phone number, portfolio, etc., who will be on the dais along with the protectee. You have just mentioned the number of dignitaries in your earlier reply. Now, thereafter, details of the staff of sound operators who will get access in close proximity of the protectee to assess their antecedents. You have just mentioned the name and contact number of the sound operator, but that was only sought for. They asked for, the query was, against serial number 6, my lord, please provide the details of sound operator and contractor cum decorator of the stage. So we had provided that. Now this is, again, my lord, a further query. Then electricity, my lord, we stated that we are using generator sets. So now they say, provide the details of all staffs of generator operator who will get access in close proximity of the protectee to assess their antecedents. You have just mentioned that soundproof generator will be used in your earlier reply. Now, thereafter, my lord, provide the details of all staffs of decorators who will get access in the close proximity of the protectee to assess their antecedents. You have just mentioned the name and contact number of the sound operators. And then they say that in the given sketch map, my lord, the sketch map has been supplied, my lord, way back and multiple times. Despite that, my lord, they have been asking the same question. Now they say that in the sketch map, distance between the dais and the barricade of the D zone is not mentioned. So provide a fresh sketch map mentioning all details of barricades, such as where the single barricade will be done, where double barricade will be done, where the gangway will be done, what will be the dimension of each block of supporters. So, my lord, we respond to it last night on protest, my lord, saying that this is in contempt. They are in contempt because they have, my lord, willfully and deliberately violated the, my lord, direction as contained in paragraph number 8.
Yes.
Because they were to forward it to the SDO, who was to process the application. Instead of that, my lord, they are doing this, my lord. So we say, my lord, we respond to everything. We further draw attention that the leader of the opposition, my lord, the reply is at page 13, that the leader of the opposition is a Z category central security protectee. And in terms of, my lord, the yellow book, my lord will find, kindly takes the second paragraph, but there is one security liaison officer who is supposed to have been detailed from the local police station for better coordination. There are watchers and security trained drivers with RT-fitted mechanically sound escort cars to be provided by the state police, and the district police is also supposed to arrange for anti-sabotage check, access control, and other security checks at the places visited by him and to be visited by him. Now, this, my lord, information which they are requiring, now these are, my lord, within the domain of intelligence input, which they are to do, my lord, confidentially, the police, my lord. This is a regulatory measure, my lord. The regulating, my lord, this rallies or, my lord, meetings, if the meetings are held in public places, my lord. Instead of that, my lord, they are, my lord, directing us to get involved into policing, because whatever information was sought for, my lord, has been furnished, but they are coming up with fresh information, one after the other. So, my lord knows, my lord, the law is very well settled, my lord. In Mohinder Singh Gill's case, paragraph number 8, it says that once an order is passed, it attains finality. It cannot be altered. Otherwise, there will be no end. But I will be relying on that particular decision, my lord. It's reported in Megha, kindly hand over the
Yes,
book.
yes, sir. Para
Yes.
Citation. अरे ले आओ यार, देव मेरा मुंह क्यों देखते हो? ये वहां से देते हूँ, वहां से लेके दीजिए.
My lord, kindly takes paragraph number 8, my lord.
1 SCC 400.
28 1 SCC.
400.
Yes.
So, my lord, they have been also, my lord, violating this particular proposition of law as has been laid down by the Honorable Apex Court, one after the other, because this is unending, my lord. We are responding. They know, my lord, that a fundamental right cannot be, my lord, negated. So they have now adopted this ploy, and that too, my lord, in violation of your lordship's direction, as contained in paragraph number 8, my lord. And instead of forwarding it to the SDO, now, my lord, they are doing this, my lord, to frustrate, my lord, the program which is scheduled today. Now, my lord, by way of filing the writ petition, the inaction, primary inaction, my lord,
Yes.
was as against the SDO, who is supposed to give permission for using loudspeakers and amplifiers in terms of, my lord, the notification published by the Department of Environment, as also, my lord, in terms of section 34A of the Police Act, my lord. So that is the primary relief, my lord, that we have claimed for.
Yes.
And thereafter also, my lord, as against prayer C, my lord, we have further sought for a mandamus directing the authorities to ensure that no obstruction is caused in any manner whatsoever in having, my lord, this particular rally and meeting. Because initially, the police sought for information only pertaining to the meeting in the writ petition, my lord, the one we have annexed, my lord. So we had responded to that, and pursuant to such response by page 36 of the writ petition, my lord. Those were the information which were sought for. There was nothing, my lord, in so far as, my lord, the rally was concerned. It was only pertaining to the meeting, my lord.
Yes.
Here also, my lord, the final query also pertains to, my lord, the rally, the meeting, not the rally. So presumably, my lord, there is no, my lord,
Well, the first
direction
paragraph
or
is
no
pertaining
formation,
to
no
with regards
formation.
regarding Lord my learned senior has already canvassed before your lordship, my lord. The first paragraph.
Yes.
But what will be pertinent in this report will be from the second paragraph onwards, my lord. I've given a copy to my learned friend, my lord. Kindly see the second paragraph onwards.
Report.
The plot number in the writ petition you lordship will find at page 39, corresponding to the second paragraph.
Page?
This plot number mentioned in the second paragraph,
Hmm.
your lordship will find at page 39 of the writ petition. That is a sketch map that they had provided to us. Absolutely at the bottom, handwritten part,
Yes.
your lordship will find.
Yes.
Though, my lord, that plot number does not exist at all in any records. Secondly, my lord, we have given the photographs. It is clearly mentioned that they have erected the pandal at a completely different place, my lord, as was indicated in the earlier application before the SDO. And thirdly, my lord, your lordships will find in one of their replies that they had merely said that at page 38, your lordship will find the writ petition. That was their reply to the first query that the police had raised. Page 38 kindly takes towards the end of the paragraph at page 38. A small stage made of iron and cloth without any roof and walls will be erected, and as such is beyond the ambit of so and so. Now, my lord, we have provided the photographs for your lordship's kind convenience, my lord. What they have actually erected is basically a
as good as a pandal, my lord. A pandal has been erected at a different land as applied for and giving description of a property which does not exist in e-Bhumi Chitro, Bhuchitro. Order a copy to them. Order.
Yes.
Now, my lord, your lordship had directed, my lord, yesterday. Well, that is the factual aspect, my lord. I have nothing more to add on the factual aspect because I stand by yesterday's submission that they have not come up against police inaction. They have come up against the inaction of the SDO in not giving permission for microphone only. Therefore, my lord, though I have the reports at the cost of repetition, I am not handing it over to your lordship, my lord, yesterday's report because that is by the police. Your lordship directed yesterday, my lord, in paragraph 8, that considering the above, this court directs the petitioner to immediately by 3 p.m. submit the information to the concerned police officer, and if the information is received by the police officer, the same may be forwarded to the subdivision officer for taking appropriate decision immediately. Well, this in our understanding, my lord, when the reply that they have given did not satisfy the queries which were raised by us on 17th of December, and that is why, my lord, we were unable to forward it to the SDO. Now, my lord, we are in a scenario, my lord, as I have pointed out to your lordship, my lord, if your lordship directs that they should be allowed to do the program at someone else's land where without satisfying your lordship, my lord, whose land is being used without producing the ROR, then my lord, I am not denying that he has a fundamental right. But the fundamental right is not to exercise it in any manner which they desire it.
No, but see, rightly, wrongly, whatever it is. Paragraph 8 said that you have asked for certain information. Your contention, your officer's contention is that this information was required. This court has directed, he has submitted. He has submitted right information, wrong information. That's why this court has, keeping in mind and directed to forward route to the subdivisional officer for taking appropriate. But where is the order? Where is the communication submitted to the subdivisional officer in terms of paragraph 8?
Well, we could not because the
Why not?
information
You could have been given. You could have been
information received by us was not sufficient. Number one. Number two.
This court has directed if the information is received by the concerned police officer, let the police officer be come in person before this court. Why you not complied with that one? Leave aside the meeting. I am concerned with the paragraph 8. Why your officer is acted over and above the order passed by you? You could have been given the observation submitting the report to the subdivisional officer.
Malad, let me, Malad, take the instruction.
Let he come at 12 o'clock here before this court. I want to be present before this court here.
But he's in Hasnabad.
Maybe. Let he come before this court in person at 12:30.
But kindly keeps it at 2 p.m.
No, 2 p.m. is the meeting. Let he come at 12:30 here. Why he has not complied with by you know. You the court officer, you the senior advocate.
Yes. No, Malad, my
he has not submitted. That's why, by keeping in mind, this line has been added by this court.
My understanding of this.
I understand. And that time I realized something will happen. That's why and this court has passed an order sent to the subdivisional officer. Subdivisional officer will take the question.
But SDO will only take the call as far as the microphone is concerned.
That is with regard to the SDO could have been passed an order. Yes, this is a report submitted by the police.
As far as this scenario on the ground is concerned, Malad, they are doing it at a completely different land.
I am not telling whether they are doing in complete land, they are not doing in complete land, whether they have submitted the report. Court has passed you. Firstly, they have given some query to the petitioner. Petitioner submitted. The petitioner filed the writ petition. After the writ petition, you again made a query of the 15. Just 15 query. This court has found yes, 15 query. Yes, it has to be satisfied by the petitioner. That's why the court has directed the petitioner to submit the query to the concerned officer, and the concerned officer shall submit the report to the subdivisional officer. Where is the report to the subdivisional officer?
But I can come back with the instruction whether it has been sent or not, and the document also.
No, you have submitted the report. Sir.
Yes, the report.
No, you cannot go beyond this report.
No,
you cannot. The
report is pertaining to Malad the queries. Report is pertaining to the land. Report is pertaining to the stage.
With regard to paragraph 8. With regard to paragraph 8.
Kindly, Malad, my lord, look at it from this
The officer should not be in the
my lord,
force.
my lord, the report, my lord, the report was really not in, my lord, compliance as an affidavit of compliance of your lordship yesterday's order. The report was, my lord, envisaged to give the fact before your lordship.
Correct. I appreciate your fact, what you have stated. I am not making any not believing your report. But the court has passed a specific order directing the officer to submit the. I know this will happen. That's why this
in
order
that
was
case, my lord,
passed.
kindly allow me to come back, my lord, in an hour with the documents, my lord, if
No,
there
no,
is any.
let the officer become the by an order dated. By an order dated 18th of December 2025, this court has passed an order. Not comma. Considering the above, this court directs the petitioner to immediately by 3 p.m. submit the information to the concerned police officer. And if the information is received by the concerned police officer, comma, the same be forwarded to the concerned subdivisional officer for taking appropriate decision immediately. Inward comma close. Today, when the matter, as the matter is urgent, today when the matter is taken up for hearing, comma, London advocate appearing for the petitioner has filed the supplementary affidavit. Filed the supplementary affidavit stating that the order passed by this court was communicated to SI Pratibhindu Das, Hasnabad Police Station, and on receipt of the said communication along with the required information, comma, the said police officer again made a communication to the petitioner on 5/04 p.m. asking the petitioner to furnish the following information. Write this, page 412. This court failed to appreciate whether the police officer, this after going to considering the communication dated 18 December 2025 at 5:04 p.m. issued by the police officer, this court find that the police officer acted over and above the order of the court. This court has specifically passed an order on receipt of the information, the petitioner, comma, the information should be forwarded to the concerned subdivisional officer for taking appropriate decision. But instead of sending the matter to the subdivisional officer, comma, the police officer has passed an order directing the petitioner to submit further information. Considering the above, this court find that the SI Pratibhindu Das has violated the order, willfully and deliberately violated the order passed by this court. Accordingly, is directed to appear before this court at 12:30 p.m. in person. This order is passed because the matter is an urgency and the petitioner and this order is passed due to urgency as the petitioner is intent to conduct the meeting at 2 p.m. today.
Physically 2.5 hours are required for coming from Hasnabad to Kolkata. We again be in violation of the order. Kindly give, what I am not on law. The practical difficulty, from Hasnabad to Kolkata is 2.5 hours. Whoever is aware of Hasnabad knows. I am not even asking for 3 hours, at least 2.5 hours be given for us to come. I am not asking for affidavit, I am not asking for anything, only
at 2 p.m.
But only one indulgence that I will be praying, since the meeting and rally is scheduled from 2, but they say that the dispute is that there is some ramp which is being constructed on someone else's land. My prayers are very specific, It is admitted they have no objection insofar as the rally is concerned. They are trying to, raise an objection with the meeting. My prayers are, that I am having the meeting in this particular, this Navadigonta Shangho ground. So, I have prayed for an interim order in terms of prayers F and G. Let the police officer come and explain his conduct. On the face of it, they are in contempt. In the meantime, my lord permits us, my lord, to do it. If the stage is on someone else's land, we will not do it. The police will prevent us from doing it, or rather, we will not go. That is
Then a
my
law order
undertaking.
situation will arise there.
That is my undertaking. We will not go. My lord records my
But
undertaking.
in that
is
case, a
the-
law and order situation will arise there. They will want to do it at that spot. They are,
No, no,
and
my
we
lord
have to,
records my
on the face of it,
undertaking.
they are doing it on someone else's land, and
My lord
my
records my
learned senior
undertaking.
submits a
These are
reply.
all ploys.
I will do
My
it.
lord,
Police
kindly,
should go and stop me.
Mr.
But that is not the intent.
Mr. Bandyopadhyay should appreciate that when someone is submitting, he will also get his opportunity.
No, my lord looked at me for my response. I thought so.
My lord, what I was humbly submitting, my lord can record my undertaking. That if the stage is on someone else's land, we will not have it there. We will have it only on this ground.
Mr. Bhattacharya, there is an order, there is a report, and there is a government record the land which you want, which you have indicated for conducting the meeting. That the land is not in existence.
But no problem, my lord. May kindly record, my lord. We will not have the meeting. We'll have the rally, my lord. The petitioner is present, my lord, in court, in person. My lord may record, my lord, my undertaking that in terms of this particular, since the dispute has arisen, though, my lord, the police never has even asked us. There have been a barrage of queries, my lord, but nothing pertaining to this. This is again another new ground. Even last night also, the mail that they sent, there was no query, nothing. They are creating ground.
They have given they gave the details.
The state has submitted the report. State has submitted report. Submitted report wherein it reveals that on receipt of the information from the petitioner, one SI Ramesh Vaidya of Hasnabad PS had been to the village Belani and noticed that the organizer are preparing for the structure of the dais on another land situated in the southern side of the proposed meeting venue. That is the land of Navadiganta Sangha ground, which also differs from the sketch map provided by the petitioner earlier. Full stop. It is also mentioned that the BL and LRO Hingalganj has been received, has submitted the report in which it is mentioned that as per record plot number 157 by 139, which is the proposed venue of the meeting, as per the statement of the petitioner, the said land does not exist in the database. In the report, the record of land has also been enclosed. Full stop. Considering the above, full stop, there is no allegation with regard to conducting the rally. This is only with regard to there is an objection with regard to the conducting a meeting, and this court finds that there is an contradictory with regard to the survey number and with regard to the plot wherein the petitioner intend to conduct the meeting. Accordingly, this court is of the view at this stage it is not proper by this court to allow the petitioner to conduct the meeting, but there is no allegation for conducting any rally. From which area to which area?
From it's page 22, my lord. From Bishpur, Pubergheri, Rajendra Patro, FP School More to Belani Bazar, Navadiganta Sangha ground.
Rajendra Patra, FP School More to Belani Bazar, Navadiganta Sangha ground. From 2 p.m. to 6 p.m. Now, rally, how much time it will take? We got 2 p.m. to 6 p.m.
We'll walk slower, my lord. We'll walk slower.
2 p.m. to 6 p.m. How many persons will be there?
But we have indicated that the total
They have
number of
stated 5,000. They have stated 5,000.
5,000, my lord.
But it's a single lane road, my lord. I'm just
5,000.
2,000 person can
But
go.
the state cannot now come up with the objection regarding numbers.
No, not that. This court is the 5,000 rally, then it will be difficult for the law and order problem.
Manoj may restrict us to 3,000 then, Manoj. Manoj may not record my concession. Manoj may let this be an order of the court.
With the 5,000 people. Considering the above, this court find that the Learned Counsel for the state has raised objection and submitted that this is a single lane road where the petitioner intend to conduct the rally, And if this court will allow the 5,000 people, comma, the land situation, there will be a problem of the traffic and the law and order accordingly. So considering the submission made by the parties, the petitioner is allowed to conduct rally in a peaceful manner by keeping in view of the law and order situation from 2 p.m. to 6 p.m. with the gathering of 3,000 people instead of 6,000, 5,000 people. Full stop. The local police authorities are also directed to make necessary arrangements for conducting of the rally by the petitioner, and the petitioner also directed that no law and order situation can be disturbed.
Grateful, Your Lordship.
Great, Kumar.
But the matter is made returnable.
2 p.m. 2 p.m.
So now I allowed this. Your petitioner will let it come on when he will come. Monday. I am
Monday
let
the
the
date
appear
fixed.
before this court.
Monday 2
person
p.m. Malad?
At Monday 2 p.m. matter है. Monday 2 p.m. matter है.
But today 2 p.m. will be inconvenient from a learned senior also. There's
No,
a
I have to take my
marriage in the
mother
chamber as
somewhere.
well as
So,
marriage in the family.
no, that part I have to take my mother somewhere. So I had taken a leave today.
2 p.m. Monday 2 p.m. for appearance of the SI Pratibandhas.
Grateful.
In person.
Grateful. Extremely grateful.
आगे तो धूप है.
Well, Hasnabad is otherwise very beautiful in winters, Malad. Your Lordship should go there once.
Sure.
My apologies, my lord, for
the rally be conducted, then we'll
Well, rallies will go on. Rallies will go on.
but my apologies, my lord, for not being able to remain present physically, my lord.
Grateful, Malad.
मेरा पास फाइल है, इसको जो है टू बी मेंशन 2 p.m. में रखो अर्जेंट मोशन में सप्लीमेंट्री लिस्ट निकालो उसको करके ना टाइप कर दो, करेक्शन भेज दो, करेक्शन करके अपलोड कर दो. Yes, call the list.
My lord, this matter was mentioned before your lordship for withdrawal, and it is wrongly appearing under the heading extension of interim order. My
Which
lord,
matter? Item number
9.
9, my lord.
My lord, this is the letter which has been addressed to you. My lord, kindly dispose of the matter.
To withdraw.
Yes, my lord.
Where is the written instruction?
We've also notified the opposite side. My lord wishes.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner submit that he has received an written instruction from the petitioner stating that the parties have amicably settled the matter and the petitioner does not want to proceed with the matter. Let the communication dated 9th December 2025 be kept with the record. Considering the submission made by the considering the communication dated 9th December 2025 and the submission made by the counsel for the petitioner WPA 29896 of 2024 is dismissed as withdrawn. Interim order is pending. Stand vacated. Stand.
Deeply obliged, my lord.
Next.
I'm grateful, man.
Item 10, I appear for the petitioner. My lord, originally after hearing the both parties, interim order was passed on 17th of April. Thrice thereafter it was extended. Today it is expiring. In the meantime, opposition and reply are ready. So usual that lordship is passing that kindly take on record the affidavits and fix on a date.
I am for the respondent. Here are my reply, my lord. Affidavit in reply.
Reply or affidavit in opposition?
Opposition.
No, yours is opposition. Mine is reply.
Reply?
Sir, my learned friend has given 2, I believe, but that is fine.
Both are given,
There
my
are
lord.
lordship has called now item 10.
Analogous.
11 is identical. Same order, everything would be same.
Analogous.
The respondent fully. So the matter is listed as to be mentioned for extension of the interim order. A respondent has filed affidavit in opposition after serving the copy to learn. Petitioner has filed affidavit in reply. After serving the copy to the learned counsel for the respondent, let the same be kept with the record. Interim order is extended till if 4 February खाली है देखो.
This will not take much time. Point of law, pure point of law.
4 February. 4th February at 2 p.m. as specific matter.
Can I have the interim order just 48 hours extra? So
Interim
that
order is extended till 5th of December, 5th, 4th बोला ना, 6th of February 2026.
deeply obliged.
Or until further order, whichever.
Lordship has recorded that I have also filed the reply. Yes, deeply obliged. 10 is same. 10. Identical.
Same. In that also affidavit.
Yes.
Yes, next. Next.
Your Lordship, I am for the petitioner. This is this is for withdrawal, Your Lordship, for non-prosecution. I have got the written instruction.
I'm appearing for the respondent.
My learned senior friend is for the DVC.
Well, withdrawals are always welcome for the court, well, for the country also.
The matters listed is to be mentioned on the prayer made by the counsel for the petitioner. Full stop. The petitioner has handed over a written communication dated 17 December 2025, wherein the plaintiff has informed the learned advocate for withdrawal of the suit. On the basis of the communication, the petitioner prayed for withdrawal of the withdrawal of the writ petition. On the basis of the communication, the petitioner prayed for withdrawal of the writ petition. Consider the submission made by the counsel for the petitioner for use the communication dated 17 December 2025, WPA 28608 of 2025 is dismissed as written. Interim order, if any, stand vacated. Communication be kept with the record.
Gratefully, Your Lordship.
Next.
But in this matter, I appear for the petitioner. But on last occasion, on 4th of December 2025, my lord has been pleased to pass an order by directing the state to produce a report.
Yes, what is the report?
But we have supplied the information as has been directed by the district land and land reforms officer, my lord. Can you see, my lord, page?
What?
There is a direction of the district land and land reforms officer to furnish certain documents which they have sought for under my lord, the provision of Right to Information Act. But accordingly, we have, my lord, submitted we have supplied the documents. That is at my lord,
page 16, my lord. Kindly turns the report.
Page 16 of my
report. Got it.
So they have supplied the information that this is the fact.
Information and documents, my lord, also, my lord. Whatever they have sought for.
No document. Only one copy later.
No proceeding was drawn.
Yes, ma'am.
This is
concluded. So that's all.
That's
in terms of the order passed by this court dated 14th of December 2025. The respondent number 4 has filed a report in the form of affidavit. Disclosing the letter dated 8/12/2025, wherein it is mentioned that as per available office records, it reveals that only notices were issued, being suo motu case number 135/2007, fixing date of hearing on 15th March 2007, 12th October 2007, and 29/11/2007. Over plot number 357, 357 by 565, 357 by 566, and 357 by 618 of Muhaza, Calcutta, JL number 719, but accordingly no proceeding was drawn off or concluded. full stop, in your comma clause. Counsel for the petitioner has satisfied that the respondents have already communicated the information. In view of the above, this court finds that nothing remains in the writ petition. Accordingly, WPA 15120/2023 with can already dispose of, na?
Yes, yes.
WP 15120/2023 is disposed of.
Grateful to your lordship.
Report the
My client was kept waiting since 2021 for this reply
What can be done?
and dragged to High Court.
Next.
Item number 16.
Item number.
May it please your lordship, I appear on behalf of the petitioner.
Yes.
My lord, we were dealers in cattle. Now we had been dealers in cattle all over, my lord, the city, and subsequently, my lord, we were rehabilitated to a particular portion, my lord, outside the city. We were settled there. Licenses were issued in our favor under the 1959, my lord, Cattle Licensing Act, and we continued up to 2014 by payment of the tenure of the licenses continued up to 2014. After 2014, we kept on making payment of rents to the state. The state accepted it, and therefore, by their conduct, it got extended. There's a finding of the division bench to that extent. Now, my lord, in 2016, that particular settlement which was there, the state disconnected the electric supply and said that you please leave this settlement because we are now going to take you out. We said the very basis on which you have resettled us here was that you will give us right to continue our trade. Our trade has not been banned. Under 19(1)(g), we have a right to continue our trade. You can put in reasonable restrictions. You took us out of the main city and you settled us in an area separately. We have accepted that. It's been acted upon for years. Now, unless you take out a policy saying, or law, policy won't do, unless you take out a law within the meaning of the exceptions of the fundamental rights saying that cattle trading, cattle rearing is banned in India, rearing is banned in India, we rear it for milk. Or the milk of cattle is banned, this entire thing, unless
of the cattle.
These are cattle, my lord, cow milk. We are actually, my lord, persons who have been generationally dealing with this business. It is for the purpose of cow milk. Now, the government says nothing doing. We are not going to permit you to continue there. You go. We file a writ petition saying it's our fundamental right. It's not been curved by any law in the meaning of 1906. Therefore, you can't just tell us to go out like this. Consider our prayer for renewal of licenses, which you have arbitrarily stopped. The Honorable Single Judge taking up the writ petition says, sorry, your writ petition is not maintainable. I don't see any legal, enforceable legal right in your favor. Plus, your disputes are, if at all, private disputes, qua renewal of a license under the 1959 Act. Therefore, writ court will have nothing to do with you. The writ petition is thrown out, not entertained, leaving us at large to invoke our civil remedies. We filed an appeal before the division bench. The division bench takes a completely contrary stand and really creates, my lord, the pedestal for our rights. Please come to page 159, the order of the division bench, delivered on 10th of March 2025. I'll just place certain portions, my lord, which are
within 2 weeks on the date of such application is filed, licensing authorities consider the application in the light of 59 Act and connected notification, pass a reason order.
Yes. Now, just 2 paragraphs of the division bench's findings, which are in my favor. Please come, my lord, paragraphs 8 and 9 at page 161, running page 161. 8, may I just place? First issue to be considered is as to whether the writ petition is maintainable. Admittedly, the petitioners were rearing cattle and carrying on milk business within Kolkata city for several generations. After the advent of the West Bengal Cattle Licensing Act 1959, the appellants and similarly placed persons were required to obtain license under the 59 Act, which act was enacted in the interest of the public health and sanitation to regulate the keeping of cattle in urban areas and for that purpose to provide for the licensing of cattle.
it is not in dispute that the writ petitioners applied for license under the 59 Act and the license was granted and a bond was also executed.
What is the decision they have taken?
The decision they have taken is they have said because your license has expired in the year 2014, therefore we will not grant you license. The entire fact that the Honorable Division Bench, being cognizant about the state of affairs, had sent it back for a decision to be taken has been completely overlooked. The state continues to maintain a stand. No, we will not allow you to do this.
Where you want to use this cattle rearing?
Cattle rearing there? Where we are settled?
In the municipal area?
No, it's outside.
Yes,
it's outside. It's outside.
No, because they have taken the 354 of the West Bengal Municipal Act.
Yes. So it is within the municipality, but it's outside, my lord. It's a settled boundary walled place. Now, my lord, we came up before this honorable court in the second round of litigation challenging their action. In that, my lord, the honorable coordinate bench was pleased, my lord, to admit the writ petition, direct filing of affidavits, and give me liberty to apply to the state to seek interim relief, because we said you can't dislodge us in the meantime. We went and we applied for interim relief. Interim relief has now not been refused. Please see Can 1 of 2025. Pursuant to the order of the Honorable Division Bench, my lord, we went for interim relief. Now, my lord, kindly see 24th of April 2025.
Page?
Can, my lord, page 44, my lord. Can 1 of 2025.
Page 53. Can কোথায়? কি হচ্ছে?
এ বাবা, তাহলে ক্যানটাই তো মামলা।
একটা কপি আছে। এ আছে। ফাইলিং মধ্যে কোনো দাগ কাটা নেই তো? না, ফাইলিং না, ঠিক আছে, ফাইলিং।
Yes.
Please come, my lord, to page 53, my lord, where we sought interim relief after the order of Justice Sinha, my lord, admitting the writ petition and permitting us to apply for interim relief before the state. Annexure D at page 53 is the order passed by the state on interim relief. After perusal and detailed examination, earlier facts are, my lord, all recorded. Owners of cattle engaged in production redistribution, kindly turns the page over. Paragraph 4, 344 of the West Bengal Municipal Act says that no person shall use or permit to be used any land or premises for keeping cattle, horse, pig, dog, or other quadruped animal, or any kind of bird for any purpose whatsoever, without or otherwise than in conformity. So there is no bar. And I am asking for a renewal.
But now what you want?
My lord, interim relief protection that I be not dislodged until the writ petition is heard out. Because my position has now become precarious. Whether they are turning out of mine after the division bench's order was lawful and justified is under consideration before my lords. My lords have directed, my lord, my lord, affidavits to be filed. No. They have not filed their affidavits in opposition. This direction was in Justice Sinha's order, my lord. Kindly see, my lord, the order dated.
That's for 18 September.
Yes.
18 September, the impugn order appears to be detailed one. Legality of correctness of the decided
upon exchange of affidavits. No scope to pass any interim order at this stage. Now, my lord, kindly see. Let affidavit in opposition prepared, circulated by November 21, 2025. Not done. Reply if any within a fortnight thereafter. It has been submitted that the life and livelihood of the petitioners would be jeopardized if the petitioners are not permitted to carry on with their business. Pending consideration of the writ petition, it will be open for the petitioners to apply before the authority for interim protection to carry on their business. In the event such application is filed, the same shall be considered by the authority. Liberty to mention the writ petition for final hearing and also to pray for interim order if occasion arises. So this is the interim order, my lord, now which we are praying for. Initially, we were sent to the state. State is going on saying the same thing over and over again. In 2014, the license had stopped renewal, and therefore, we do not have any right today. The Honorable Division Bench was cognizant of this state of affairs and said that please consider their application for extension or renewal because they're carrying on a business for generations. You have resettled them in a part of the, away from the din of the main city. You have resettled them within closed boundary walls. They are there, they have put up structures, they are carrying on business. It's a 19(1)(g) right. My lord, kindly consider, my lord, Olga Tellis once, the worst possible case Olga Tellis was for the squatters.
Yes, what is the contention?
My lord, regarding section 3 of the West Bengal Cattle and Licensing Act, my lord.
Correct, that is the matter of the fact. You have filed the affidavit in opposition.
No. That is our default, my lord.
Court has already directed to file affidavit and the matter is also directed to consider the case. You have not considered the case for interim order. You have not filed the affidavit in opposition. If today I will not pass an interim order and you will evict the petitioner, so tomorrow if the court will find that he is entitled to get the license, where he will carry the business.
But you kindly give some more time so that I can.
Okay, I am staying the order. I am directing not to evict the petitioner till the decision of
But
the court.
because this order is passed on 2nd December, my lord.
Correct. 2nd December 2025.
May I
You have not filed the affidavit in opposition.
May I come in Monday, my lord?
Why? Monday any situation will change.
Because, my lord, I have no instruction regarding this order is
What
passed.
is kindly see the total. You read the nine-page order.
Because
The instruction is
just
in the order itself. Not
this order
required
is
to study
concerned.
further.
This order is concerned, my lord. I want to take instruction because they are facing the interim.
I am only 2 points. Correct. This court initially has not granted.
Yes, my lord, my lord.
And you prayed for the affidavit. Court has granted affidavit. 2 weeks, 3 weeks, whatever it is. And the court has also given a liberty. All the things has been in your favor
Yes,
in the first order, 18 September.
Yes, my lord. The order.
Is your favor. You have not allowed the interim order. No problem, it is your prerogative. But now the affidavit you are not filed. And now you are not taken the instruction. So what the court will give? Or you give the undertaking, you will not evict. I will. You
Because
take
I have not
instruction.
given
You take instruction. And
So kindly keep it
first
on
week of January.
Kindly keep it on Monday, my lord.
Monday, I have no time. This court is not having time for Monday, Tuesday. I am fixing the matter on 7th or 8th. You are having full 1 month, 15 days time to take instruction by sitting with the all authorities and come.
But I am opposing the interim order, my lord.
Huh? Yes, what is the objection? Tell me.
Regarding objection is concerned, my lord, there is specific in clause 13 of the
Okay,
agreement
we have
is
gone through.
specific.
You
There
tell
is no
me.
agreement at all, my lord.
You give the answer to this court only one query. I accept your submission is not entitled to get the interim order. I will not pass an interim order. Tomorrow, if the court finds that he is entitled to get the license and court pass a mandatory order for grant of license, correct? And you evict the petitioner in the meantime. So what would be effect of the granting of license by the court?
There is no agreement at all, my lord. There is no agreement for.
I am putting a question. That's why agreement. So if that he will be evicted, pendency of the writ petition, and at the end the court finds that the petitioner is entitled to get the license for rearing of the cattle in the particular land, and you are already evicted and you have given to the other authority for multiple building,
yes,
multi-storied building. So what will happen to the license where the petitioner will carry the business of rearing of cattle? Tell me, give the answer. I will record your submission. I will reject the application. It is
I
totally.
appreciate my lord's agony, my lord. I appreciate my lord's agony regarding the if my lord's was queries, my lord. That is the question, my lord. Well, kindly regarding my I am opposing the interim orders, my lord. If my lord pleases, then my lord passes orders.
The petitioner has filed the
And my lord are giving liberty to file an affidavit in the meantime, my lord.
petitioner has filed the present application challenging the order passed by the Assistant Director and Cattle Licensing Authority dated 24th of April 2025. The matter was taken up for hearing on 18th of September 2025. On that set date, September 2020, this court has directed the respondents to file affidavit in opposition by 21st of November 2025, a reply, if any, within a fortnight thereafter. This court has also given liberty to the petitioner to apply before the authority for interim protection to carry on their business. In the event the application is filed, the authority is directed to consider the application of the petitioner. As per the liberty granted by this court, the petitioner has preferred and made a prayer before the concerned authority. The concerned authority, by an order dated 2nd December 2025, has rejected the claim of the petitioner, holding that, inward comma, therefore, comma, after considering the above aspect and going strictly by the West Bengal Cattle Licensing Act, 1959, and the West Bengal Cattle Licensing Rule 1985, And as there is no provision of issuing provisional license in the Act of 1959, and also as the land where the petitioner were rehabilitated is required to be vacated for other projects of the government, comma, the application of the petitioner for interim release hereby considered and rejected, comma, close. Today, when the matter is called, it is informed by the learned counsel for the petitioner that though the authorities have rejected the request of the petitioner, but the respondents have also not filed the affidavit in opposition in terms of the order dated 8th of September 2025. Learned counsel for the petitioner submits that if though the authorities have rejected the request of the petitioner for interim relief, and if at this stage an interim relief is not granted, comma, during pendency of the case, comma, there is every chance that the respondents will evict the petitioner from the land in question. Full. Learned counsel for the petitioner further submit that by an order dated 18 September 2025, though this court has not passed any order, but liberty is given to the petitioner to pray for interim order if occasion arise. He submits that after the impugn order dated 2/12/2025, the petitioner has a cause of action to renew the prayer for interim order. Learned counsel for the respondent submit that the request made by the petitioner were considered by the authorities with all aspects as well as the law, and find that the petitioner is not entitled to get an interim order. Accordingly, the request of the petitioner was rejected. Consider the submission made by the counsel for the respective parties. This court find that by an order dated 2/12/2025, the authorities have rejected the request of the petitioner on the ground that there is no provision for issuance of provisional license in the Act of 1959. And from the order itself, from the order also reveals that the respondent authorities are intending to evict the petitioner and to allot the said land for other projects. Considering the above, this court is of the view that if in future,
my lord, kindly mention that 2001 to 2025, my lord, they are not apply for the renewal of the license, my lord. That kindly may be recorded.
It's foolish. This court find that in the present date application, the petitioner has prayed for grant of license, and at the end, if this court find that the petitioner is entitled to get the license, and in the meantime the petitioner is evicted from the property in question, it is very difficult for the petitioner to start the business of the cattle rearing business in the premises in question. Accordingly, this court finds that the petitioner has made out a prima facie case, and till the disposal of the case with regard to the nature, character, and possession of the land is to be maintained, and status quo to be maintained with regard to the nature, character, and possession of the property. Accordingly, respondents are restrained from taking any action against the petitioner for eviction of the petitioner from the property in question till the disposal of the writ application. The counsel for the respondents prays for extension of time. Let affidavit in extension for time to file affidavit in opposition. Let affidavit in opposition be filed by
1 week after vacation. 1 week after vacation.
1 week after winter vacation. Reply, if any, thereto within a week thereafter. This is the matter. So it is a preliminary.
Lordship.
This is the matter on 5th को देखो खाली है फरवरी में कौन सा जनवरी में कौन सा डेट खाली है हियरिंग के लिए फरवरी में देखो कोई डेट खाली है 28 जनवरी खाली है 28 January at 2 p.m. as a specially fixed matter.
Grateful, my lord.
Can is for interim order.
Can is for interim order.
Can is disposed.
Order said not status quo as regards nature, character, and
Possession of.
I am appearing on behalf of the state, your lordship.
I have to. Second round. Yeah, give the service. So the second round with regards to two badminton players who had initially been suspended on some particular ground. The Lordship had found that the suspension, they must go back and the board must take a decision. And as usual, and as shown, as usual, the board has taken a decision and has now imposed the penalty of 6 months suspension. So I just request Mr. Bojendra to consider this. If it's not agreeable, then I have to trouble you also. 24th, I am already ranked 1 in that entire rank of play. 24th, there is a tournament that is starting for selections for nationals, if I'm not mistaken. If I'm allowed to play that, then I'll come back and trouble you after the vacation. They don't allow me to play that also. Because for 6 months, if I'm gone, not my life is over.
So you have been suspended. How you been allowed to play?
So then I'll just indicate 2 points on which I say.
I don't know, but subject to Mr. Majumdar.
Agreed, considering these are two 21-year-old boys and who are ranked 1. Then 6 months, and then because of 6 months suspension, I'm actually going out of contention for the next 6 months also. So what happens, because I can't be part in the transfer next year. So if Mr. Mundar is agreeable to have me play this 24th tournament, I can come back reopening and trouble you lot. If he indicates that,
My instruction is not after this incident, not we are finding it difficult to persuade the parents to send the girl players.
I'll address you. I'll indicate. Well, this parents and all that, I'll show what has happened. Yes, you will have a look at 2 things. I'll just indicate. This complaint is on the basis, this entire show cause has been given on the basis of a particular complaint. That complaint has been withdrawn. Point 1. Second, the entire issue, which is 3 persons are named as so-called management witnesses in the show cause notice. 2 persons are named. A third person's version, although not mentioned in the show cause notice, finds mentioned in the final order, very heavily relied upon, as somebody who is a member of the Yonex team has come and made these allegations against the petitioners.
Witness examined.
Witness not examined. Apparently, an opportunity was given to me. I have declined. But this I'll show that your Lordship is aware now. Your Lordships have laid down that who are management witnesses. You'll have to let me know, because that gives me a right to cross-examine that person. Now, a person who was not even named in the show cause, his version has been relied on to pass the final order. Second, more shocking, we have, after this order was passed, because we didn't even know about his existence from anywhere, we write to Yonex saying, this gentleman, why is he from your team? Yonex has replied saying, there's nobody like that at all. There is no such person with us or has ever been. That if your Lordship wants, I'll just produce it. So my first ground is that this has been done completely with a malafide motive. Why? Because the gentleman who is at the helm of affairs of this badminton association, I was actually in his camp. And these 2 petitioners were either 1 and 2 in between each other. I leave that and I go to another camp. And they utilize this one particular alleged incident to keep me out so that I can't play at all. These 2 boys, before your Lordship, are, I think, 20 and 21 years old.
But this is not the incident of the table tennis, the tennis court. It is the incident of the
in the hostel. Now, my lord, apparently, I had consumed alcoholic drinks and I had caused a ruckus. This has not been substantiated through anything. There has been no test. There has been no finding. There has been no alcohol test. And as one glaring thing I'll show to your Lordship. This meeting is called on 5th of September. Urgent council meeting to decide to send it to disciplinary committee. In that committee meeting, it's referred that somebody who was with me has informed me over the phone. When they disclose, I find a written document on 5th of September that the person has given it in writing. The story can't sit, because the urgent council meeting, I'll show that. Your Lordship will just have a look at one document. I'll assail this on 3 counts.
Where is that? Where
Yes.
is the impugned order?
Yes, your Lordship will find the impugned order at page 176.
176.
176.
Decision of disciplinary committee, my lord, it is replete with how sports people must have electrolytes and can't consume alcohol and a lot of other what is required in modern day sports. But while in their endeavor to throw me out, they missed a few things. My lord, I'll just, your lordship will please turn over to internal page 6.
Yes.
At the bottom, 182, please have a look at one thing, my lord. Last sentence. Those who were there informed that on 4th September 2025 evening,
Where from your
182, last sentence.
Yes,
Those who were there informed that on 4th September 2025 evening, one Mr. Mitro, who was subsequently identified as Sri Shoikot Mitro from Yonex, complained to the reception that those who were staying in room number 304, the two petitioners, were causing nuisances and shouting in filthy language, totally drunk since afternoon, and even so and so. Lord, please have a look at this one communication. This has come to me yesterday. I could not prepare a supplementary affidavit. Eta na? Eta to? Which is where is the reply? This is the reply from Yonex team. At the top, your lordship will find. At the top, please see. Writing to one of the petitioners, 16 December, dear sir, please be informed that we do not have and have never had any association in any manner with Mr. Shoikot Mitro. We hope this addresses your query. This was a fictional person. Completely fictitious person who was never produced. There was no such member from Yonex team. There was no such gentleman also there. His version is relied on. His testimony is not taken.
No, order of the disciplinary authority is appealable.
It's appealable, my lord, that too in a way where I have to prefer an arbitration. I have to, the rule, I'll show that the rules require that I'll have to go for an arbitration and that will go on for 2 years. This will be a 6 month. So what I'm trying to very humbly try and establish, my lord, that there has been a complete breach of natural justice here. That first question that your lordship put to me, that where the witnesses cross-examined, this is one of the primary grounds on which, at page 183, this entire thing has been initiated. There is no Shoikot Mitro. The other thing, my lord, your lordship will find that the complaint that was made and the entire thing apparently started. Please have a look at page 27 once.
Page
27.
No, who has sent this mail?
So the Yonex team, who was the head of the Yonex team. I wrote to me.
No, this 16 December mail which you have relied upon.
Yes, my lord, I write
Send
to,
this.
your lordship will find my email at the bottom to manager, sir. Yonex Sunrise India Private Limited. So this is the Yonex team manager. They reply to me, Neha Mahalwal, so and so, on behalf of Yonex, that there was no such person who was ever associated with Yonex team. There was no Shoikot Mitra at all. One more thing, your lordship will please see.
Yes.
And here in the email, your lordship will find a right to Yonex Sunrise, saying that the association has said that at that email, your lordship at the bottom, kindly see the second paragraph.
The Shoikot Mitra was not named in the show cause notice.
Not there in the show cause notice. It not full name, it's just named as Mr. Mitra. And in the disciplinary, in the final order, it comes as Shoikot Mitra from Yonex. Yes. And now I'm showing Shoikot Mitra from Yonex was not even there. He was not called. He did not testify. And his complaint and one more complaint is the initiating complaint. That other complaint, my lordship will please have a look at page 27. But all I can do is highlight the malafide with which they have proceeded against me. Two more documents I'll show, my lord. Page 27, your lordship will please have a look at.
Yes.
7 September 2025. to Shekhar Vishwas, the mastermind of this entire thing. I hope you're doing well. I wanted to take a moment to clarify my earlier response regarding the recent incident involving some of the players. Upon reflection, I realized that I may have overreacted in the heat of the moment without fully understanding the situation or investigating it thoroughly before raising a concern. There was certainly some miscommunication at that time, which contributed to the confusion and escalated the matter more than it should have. While a complaint was received from the hotel, in hindsight, the situation may not have warranted the level of concern that was initially expressed. I accept responsibility for not taking a step back to assess things more calmly before responding. The players involved, to the best of my understanding now, did not engage in any serious misconduct or create significant disturbance. Given this context, I believe they deserve a fair chance and should not be judged too harshly based on this incident alone. Moving forward, I will ensure that such matters with more care and ensure all sides are heard before drawing conclusions. I appreciate your understanding and hope that the players can be given the benefit of the doubt in this. Who is this gentleman? He is the Jharkhand Badminton Association organizing committee member who had complained. And now your lordship will see the
Why you are not examining him as a DW?
Because he had already withdrawn it.
Correct.
I actually, Milord,
So you could have been examining this person.
Milord, these two boys were sitting there. When I met them, even in chamber, they have no idea how to go about it. I'm not saying that, Milord, I can't come and feign ignorance of something. But the fact is that the complaint, and I'll show one more document, Milord, the council meeting. Page 129, your lordship will find the show cause. And I want to indicate one thing, Milord. Please have a look at page 136 once.
Yes.
This is the emergent council meeting held on 5th September 2025 at 4:30 p.m. Your lordship will please have a look at the second paragraph. He informed that this morning, when the matches of ongoing East Zone championships are played at Jamshedpur, Sri Prabhakar Rao, the organizing secretary and honorary general secretary of Jharkhand Badminton Association, complained to the Bengal team present at the venue that two of the Bengali so-and-so petitioners were found consuming hard drinks on 4th September at so-and-so, who were both sharing the room, creating nuisance, misbehaved. This Prabhakar Rao is the email that I showed at page 27. He's the one who's withdrawn it. Now kindly have a look at 136, Milord. Bottom last paragraph. Shekhar Vishwas informed that Sri Tanmoy Banerjee, Assistant Secretary and Manager of Bengal team, immediately informed the incident and the complaint to him over phone. Please stop here once, Milord. Please see what is there along with the charge sheet. Show cause. Yeah, at 148, please have a look at. This entire thing, I'm pointing out dots, Milord, how this has been done, only to go after me. 148, please see. Tanmoy Banerjee, at the bottom, 5th September.
Yes.
In writing. So this could not have been over the phone. He has informed because Tanmoy Banerjee was with me. On 4th September, 5th September, he's informing them. And 5th September, he sends this confidential verification report. And please have a look at the verification report also, same Prabhakar Rao. And again, your lordship will find 148 at the bottom, evening, one Mr. Mitro, associated, second paragraph, Milord. After so-and-so complained, myself, Kiara, went to the hotel Darshan, where both petitioners were sharing. On inquiry, the hotel reception told us that yesterday evening, one Mr. Mitro, Lordship has it not, page 148 bottom?
Yes, yes.
The hotel reception told us yesterday that one Mr. Mitro associated with badminton, I don't know what that means, first complained to the reception that both players were drinking since afternoon and vomited in front of one room door and hotel staff, and when clearing, players in drunken state abused. Now this Mr. Mitro this is how he is mentioned in the charge sheet, in the show cause notice. His name and particular is given in the final order. So this is the version that's relied on. Management witness, not produced. Naturally, no cross-examination allowed. This Mr. Mitro I am now showing, whose identity is later disclosed, and I can't lose sight of that fact, Vinod. I can't lose sight of the fact that is later identified. How was he later? When did they identify?
What was your reply?
Well, my reply was saying I have not done anything. I'll show that what my reply is. And I've said that if I've done anything, please forgive me. What else will up? 172.
Yes.
I categorically deny all, second paragraph, no? All allegations leveled against me in the said notice. The statements made therein regarding alleged consumption of alcohol, creation of nuisance, misbehavior or misconduct are completely incorrect, unfounded, misleading, and not based on true facts. At no point did I commit any act that would bring disrepute to the association, my teammates, the sport, or the state. I further state, and then he goes on. And I mention here that this person, Prabhakar Rao, he's withdrawn the complaint. This is the man who's the association president or secretary of Jharkhand Badminton Association. He writes, on hindsight, I have overreacted. I did not assess the situation. I should have made an inquiry before making that complaint. So two people were there. And if I show the other two management witnesses, who were there, they have also relied only on Prabhakar Rao and this so-called Mr. Mitro.
Yes.
Whose identity was later identified. If I may just put this question to myself, at what stage did they identify him? After my hearing and before passing the order. That you could not give me the name, so I could not have found out if there is any such person at all there or not. Later identified as Shoikot Mitro from Yonex team.
Yes. Anything?
Yes, Vinod. Now, one more aspect. Just please have a look at page 182. One 182. 182 second. Well, please have a look at the second paragraph.
Yes.
Personal hearing before the disciplinary committee took place on 29 November 2025. The petitioner was also concerned. Team management official Sri Tanmoy Banerjee, Kia Mojumdar, being the members of the team, please mark the next man. Ashutosh Tiwari, one of the coaches, appeared before the committee. The show cause notice makes no mention of this gentleman. I'll show the show cause notice once more. There are two people mentioned. It is at page 129. At page 129, Your Lordship will, at page 130, please have a look at the second paragraph. On being so complained, you were still not at the venue. Both managers, X and Y, rushed and had detailed enquiries, and from the staff we confirmed amongst others that you and the petitioners had been drinking so and even vomited after another hotel. Now again, this Mr. India pops up. Shri Mitra complained to the hotel reception in the evening of 4th about the nuisance. Now, please just give the rest of it a cursory glance, my lord. Your lordship will not find the name of this gentleman, Ashutosh Tiwari, whose name is there at page 182, ever mentioned in the show cause notice. Now, my first issue on law is that if I am not informed of who the management witnesses are, and have not been, first question that came from the court.
So only after the hearing, you file the report, reply. Hearing, what has happened on the date of hearing?
On one date happened. I was sitting there, these persons came, I gave my version, they gave their version, over, then the order comes.
Who gave the version?
These three persons, name at 182.
All video recorded, not I can produce it.
Yes, yes, of course. That's
What
not
was
the
asked
point.
to do,
I was
what
not
to do.
told.
It's not as if,
One,
it's not what as is.
100%, Mr. Mojumdar will have his say. Please have a look at 182. These three persons who were called, I understand that Tanmoy Banerjee and K.A. Mojumdar were there. They were named in the show cause. Yes, I did not have the understanding that I can even cross-examine them and ask them questions. So I did nothing. They were my coaches. I sat there with some amount of deference. But this gentleman, legally, if I forget everything, Ashutosh Tiwari as one of the coaches, and his version has been relied upon. So a management witness who was there, who was not informed, his evidence is taken into consideration, me being denied the opportunity of cross-examination, is the first issue I want to address your lordship on, my lord. This is 2018, copy? Achhe. 2018, volume 12, Supreme Court cases, page 41. Shortest judgment. (2018) 12 SCC 41. Paragraph 3. The matter was taken by way of industrial dispute under so-and-so, held that charges 2 to 5 stand not proved for the simple reason that the statements of the passengers which were relied upon by the appellant corporation were specifically denied by the respondent, and he had stated that he had issued all the tickets for which the fare was charged, and the allegation that no ticket was issued is false. The industrial court held that as the passengers were not produced in the inquiry, the statement recorded by so-and-so from the passengers cannot be taken in evidence, and as no opportunity was given to the respondent to cross-examine. So on both counts, my lord, the Yonex team, so-called identity who is come out later, you could not have relied on his version unless you produced him in the inquiry. And the second limb of this is that whoever you have relied upon, you had to allow me a right of cross-examination. You can't have a person who's appearing suddenly, who's not a management witness, is not named in the show cause and has come here.
Yes. Anything further?
Yes, Manoj, just to highlight that whenever there is a violation of principle of natural justice, there is a presumption of prejudice, and it's in breach of my fundamental right. This I'm only going to show.
Yes.
But S.L. Kapoor and Jagmohan, in a landmark decision of this court, delivered delivered more than a delineating the contours of principles of natural justice, more particularly the right to be heard before one is condemned. The supersession of New Delhi so-and-so was challenged on the ground it was in violation of principles of natural justice, since no show cause was issued before the order of suspension was passed. Linked with that, this, Minon, was the question whether the failure to observe the principles of natural justice matters at all. If such observance would have made no difference, they admitted indisputable facts speaking for themselves. The golden words of Justice Chinnappa Reddy speaking for the three-judge bench rings in our ears. In our view, the principles of natural justice know of no exclusionary rule dependent on whether it would have made any difference if natural justice had been observed. The non-observance of natural justice itself prejudice to any man. And proof of prejudice independently of proof of denial of natural justice is unnecessary. It will come from a person who has denied justice, that the person who has been denied justice is not prejudiced. So, and then it goes on, my lord, to see if your lordship just gives it, it looks at Olga Tellis and all of that. And paragraph 5, what I was trying to just harp on, my lord. This is the Ram Prakash Singh. This, if I'm not mistaken, is Justice S.B. Sinha's judgment, Ram Prakash Singh. 5, it has been held that just as Articles 14, 19, and 21 constitute a triumvirate of rights of citizens conceived as charters on equality, freedom, and liberty, the trio of the Constitution Bench in Olga Tellis and Tulsiram Patel and A.R. Antule formed the bedrock of natural justice principles regarding as part of Article 14 and thereby obviating the need to demonstrate prejudice if a challenge were thrown on the ground of violation of Article 14. So, simpliciter, my lord, if I can show that there is a breach of principle of natural justice, then it's in violation of Article 14. So, 4 things now, my lord, if I have to sum it up, at least at this stage for your lordship to consider to allow me to play on 24th, because it's what I've trained all my life for. I understand, my lord, there is some complaint, some politics, something happening somewhere. My 1 year, if I'm suspended for 6 months, it actually has an effect of 1 year me sitting out of the sport.
That a badminton player, how you can use the alcohol?
I'm sorry, Milan.
Being a badminton player, how you can use the
My brief is to deny. But if I may just put it on a reverse, because there's one more judgment I'll show. What affects the livelihood of a person or the life of a person when you're denying him that, the test and the onus is much higher. Here,
but you know the game rules.
yes,
Once
I know the game rules. There is no shying away from that. I know the game rules. But
it is not a normal situation. It is the players and
who has
players
gone?
with regard to the drugs and all these things is very strict.
Yes, yeah, that is true. Now, the only other thing, my lord, is just that the person who had made the complaint, who's the initiator with his complaint, later records that he had done so without any enquiry and he withdraws it. The person whose version is taken to be at the hotel, whose identity is somehow later identified.
Okay, next, what is the judgment further?
Just Whirlpool, Milan.
Whirlpool, opportunity of hearing.
Whirlpool, no, because I want to.
Anything further?
Just, if you'll actually give me 2 more seconds, Milan. No, Milord, this is because the other one also relies on SL Kapoor and all of that. So there's no other.
Yes,
Whirlpool I'm not citing because I want to get out of the
principle of natural justice.
principle of natural justice. Only one request, not this entire time that I've wasted, is just for your lordship to consider whether I could play that tournament on 24th.
24th of December?
24th of December, that tournament starts. And I was hoping Mr. Mojumdar would be there. He's a sportsman himself. So he would have probably the sentiment would have echoed with him. Personally, I feel for them. A lot of people.
That's why he's appearing for this.
Yeah. But we are the association. No, he's a very good sportsman himself. I don't know if your lordship is aware of that. He's extremely fit. But this entire thing was just for that. I want to play, my lord. If I just take that away.
Okay. Yes, Mr. Majumdar. You on 2 questions first you give the answer, then I will follow. The case started on the basis of Prabhakar Rao. Prabhakar Rao was present? No. If the complainant is not present and subsequently there is a document, the complainant is giving away the complaint, what would be effect of that?
Please come to the answer at page 183, 187.
They disbelieve their own witness.
Please come to 187.
Yes.
The mail of the second paragraph on that page.
Yes.
The mail of Sri Prabhakar Rao is an interesting reading material drafted skillfully. While it is true that Sri Rao, by his mail dated 7 September 2025, requested for looking at the complaint leniently, but he didn't claim that his complaint made on 5th September 25 before the team management of Bengal was false or incorrect.
Correct.
While reiterating that the hotel management complained to him, but surmised that the situation might not be in the level of concern that was initially expressed. The relevant portions read as quote unquote, while a complaint was received from the hotel, in hindsight, the situation may not have warranted the level of concern that was initially expressed. He did not say that there was no incident as complaint, nor that there was no complaint from the hotel, and clearly admitted that he did complain earlier and there was gravity of the charges. Moreover, the two experienced managers of West Bengal Badminton Association, none of whom have any animosity towards Aditya Mandal or any player, immediately went to the hotel and made direct spot inquiries and confirmed what complained by Sri Rao. After interactions with the hotel personnel, their inquiry report remained unchallenged and uncontroverted. Thus, the strong probabilities do indicate that Sri Rao was either influenced and manipulated to soften his complaint, or that he all on a sudden became sympathetic towards the charged players, forgetting the basic principles of discipline. Though entire stance of Sri Mondal was based on reliance of the mail dated 7 September 2025 of Sri Rao to the General Secretary of the Association, Sri Mondal neither proved how he got the said mail, nor produced Sri Rao to corroborate, though the team management submitted its inquiry report and deposed, confirming both in writing and through evidence what actually did take place. Thus, no proper credence could be given to the mail of Sri Rao without substantive corroborating cogent evidence. It was only Sri Rao could have personally deposed as to what he changed and what he meant in the mail, but he was not made to appear even virtually. Admittedly, Shoikot made false statement and that till going to the court, he was not given any document, and his knowledge was only from the website of the association regarding suspension. Service of the suspension letter through his WhatsApp on so and so is on record.
That is okay.
No, that is there. Now, we are dealing with a case of suspension, not in respect of an incident which was taken in a different state, and not we had to deal with situations not on the basis of the application of the test of preponderance of probabilities in a domestic inquiry like situation. Not even hearsay evidence is permissible in inquiry.
That is correct. Okay, you have given the total considered that. But once the complainant, he should have been present before the inquiry when the other persons were present.
Yes, other persons had deposed.
Correct, they were, but the main complaint has been initiated on the basis of Prabhakar Rao.
But he had informed this incident to us.
Correct.
On the basis of this, we had to send two officials to the Jamshedpur for the purpose of spot inquiry.
Correct.
They came back and gave written reports.
Correct.
These gentlemen were produced at the inquiry.
Correct.
They said that we had talked with the hotel staff, with the officials, and not situation was that grave that we had to persuade the gentlemen, the officials therein, not to lodge an FIR with the local police station.
That's correct. Only my concern is once, because the case started from the complaint of Prabhakar.
Yes.
Correct. Then whatever the subsequently you have sent the persons, inquiry conducted, and so cause issued, whatever it is. And the regular inquiry was conducted, they have been given opportunity present. So without examining the complainant, what would be the effect of the complaint?
Not one had lodged a complaint.
What would be effect of the decision?
Not he relies on a statement of that Mr. Rao.
No, leave aside that. I am not on that.
I'm not. He had brought.
Leave aside the 5th September letter. Leave aside that. I am telling, once the complaint on the basis of which you initiated the complainant, he was not present during the inquiry, what would be effect?
Yes. There was a complaint made by Mr. Rao on the basis whereof officials had gone to the spot and conducted an inquiry. And the persons who had talked with the staff, hotel staff, of course not there. It's not an inquiry where we can produce those hotel staff at the inquiry in Kolkata.
That I am not.
But those persons who had talked with the officials, who had talked with the hotel staff, they had deposed at the inquiry. Please come to me now the email, but that could at the most be a mitigating factor for the purpose of reducing the punishment, nothing else. Now please come to the mail of Mr. Rao at page 27. But three things stand admitted from this letter. despite not this partial withdrawal.
No, even that's what I'm telling.
My lord.
Even let this not to be considered. 5th September not to be considered. Correct. Not to be considered. He has sent a letter asking for the leniency, whatever it is. The question that unless from where the genesis has started.
Yes.
And the person has not come, or you are not examined, or he was not present during the inquiry. So can you say this has been corroborated by the other two witnesses regarding the inquiry?
These persons who had deposed at the
That
inquiry,
is the principle.
they are the persons who had gone and made a spot verification or inquiry. They say that we were told of this. These are the email of complaint.
Where that inquiry report?
Yes.
Where is that inquiry report?
That.
Which you relied upon?
Yes, please come to.
On the report of the
Please come to. Yes.
Inquiry was conducted.
At page 148.
No, I'll just show.
148.
148 with that is the statement of Tanmay.
Right.
That is the inquiry report.
Cannot be.
That is the inquiry report. There is no other inquiry
That's the
report.
spot inquiry. Yes, please come. Page 148.
Yes.
Shri Rao, Jharkhand Badminton Association complained to Bengal team management in the presence of observer.
Yes.
Shri Nilin Kumar and Shri Rana, coach of National Center of Excellence, Guwahati. When we arrived at the venue in the morning today, that two of our players of the team, Shri so-and-so, consumed drinks yesterday at the hotel and made nuisance there, including vomiting and ruckus, and he is going to the police to lodge FIR unless both of them are removed from the hotel. So that persons from different states complaining against Bengal.
Correct.
Shri Rao was extremely agitated. On being told so, we managers immediately asked the coaches not to permit any of the two players to take any further part in the tournament till further instructions. Yesterday morning, after the Bengal senior team lost team championship matches, both Sri Mondal and Sri Banerjee left and did not come to the venue thereafter, though all of our team management were at the venue for other Bengal matches. After Sri Rao agitatedly complained, myself and Srimati K. Roy Majumdar went to the Hotel Darshan where both Sri Mondal and Sri Banerjee were sharing room number 304. On inquiry, the hotel reception told us that yesterday evening one Mr. Mitro associated with badminton first complained to the reception that both players were drinking since afternoon and vomited in front of the room door. And then hotel staff went and when clearing, players in drunken state abused and misbehaved with the hotel staff. The hotel management thereafter complained to Jharkhand Association and to Sri Rao. On further inquiries from the staff, we found the complaint to be true. This was on the basis of a spot inquiry. And please come to his statement now.
Yes.
He tries to make out a case of bias because of these two persons being eliminated from the ranking. Two other persons would step in and they will participate in the forthcoming tournament. Please come to paragraphs 12, 18 and 20.
Page?
Paragraph 12, 18 and 20. They feign ignorance, they plead bias, and every time behind the back.
Which page you are referring?
Paragraph 12, if your lordship kindly takes paragraph 12. At page 6.
Of writ petition?
Of the writ petition.
Yes.
It is pertinent to mention herein that no inquiry was made for such verbal complaint. The petitioners were not even taken to alcohol test, and without going into any affirmative inquiry or tests, the association had taken such a life-changing drastic step for the reasons best known to them. Now please come to paragraph 18. I'm sorry, paragraph 20. No, paragraph 18. I'm sorry, paragraph 18.
Yes.
The show cause notice highlighted that the petitioners failed to abide by the provisions of Rule 14 of the Constitution, and therefore the petitioners were put under interim suspension for 6 months. This was a well-thought plan executed by a powerful office bearer of the authority, being the General Secretary of the West Bengal Badminton Association, namely Sri Vishwas, to hinder the petitioners from playing nationals, which starts from December 22, 2025. Because currently the petitioners represent a separate private badminton academy. Previously, the petitioners used to represent the academy which belonged to Mr. Vishwas, but due to personal reasons, the petitioners could not continue the same. This did not fit well with Mr. Vishwas, as a result of which he initiated the entire narrative around alcohol and abuse. Now, does this behove? Not 5th September, there is a complaint made by some other state organizer. Without any prima facie evidence to back such a claim, since the petitioners are rank 1 holders from the state of West Bengal, therefore they are entitled to appear for the national championship. Then not paragraph 20. No, sorry, 19. The petitioners submitted a detailed written reply, categorically denying each and every allegation. The said letter was placed on record the absence of any alcohol test, witness statements, or in the case of the petitioners, not even a written complaint was on record before the respondent authorities. Till date, no written complaint has been made. It has been relied upon by the respondents to accuse, frame, and then suspend the petitioners. Suspension is equivalent to blacklisting. Suspending without an independent inquiry or unverified complaint also tarnishes the suspended person's reputation and goodwill in question. Once suspended, the next eligible players to represent the state in the national championship shall be ranked 2 players, and coincidentally, the rank 2 players belong from the same club which was founded by Mr. Vishwas. This demonstrates a desperate attempt by Mr. Vishwas, as he is destroying the life of talented players like that of the petitioners for personal gain. Even the organizing secretary, being the first verbal complainant as per West Bengal Association against the petitioners, later retracted his statements via mail on the last day of the tournament, which has been annexed therein. Mr. Vishwas, along with being the General Secretary of West Bengal Badminton Association, holds various other positions such as so and so. But all these allegations of bias sought to be made behind back once again. But it has to be now presumed that on 5th September 2025, some other official of a different association had been a part of this hashed up conspiracy to prevent these players from participating in a subsequent tournament. Rights of 2 other players who have been nominated for the tournament commencing from 24th has now accrued. The number 2 have been sent for the purpose of participating in the tournament. But today, by way of an interim order, he seeks a final order, which has been actually long back disapproved, not in the by the Honorable Supreme Court in cases of suspension. Please come to paragraph 38. Of this report. From the, I just come to the summation part where the Honorable Court had summed up the submissions, or has given its views. From the above quoted decisions, it is evident that this court has consistently been of the view that by way of an interim order, the order of suspension, termination, dismissal, and transfer, etc., should not be stayed during the pendency of the proceedings in the court. Now, today, my learned friend wants to make out a final case. Not everything was videographed on the date of inquiry, and this was really on the basis of an arrangement. I mean, the direction passed by this Honorable Court, making it a time-bound program. Now, we had issued the show cause notice. He had given a detailed reply. We asked him to be present with all the witnesses, but he could have at least persuaded Mr. Rao to depose on his behalf through online mode and say, not at least there was an occasion of occurrence of incident is borne out from record. What actually happened, not these 2 gentlemen who were there on the spot inquiry, they had deposed. But we can't take this to the level of a criminal trial.
Yes.
Now, please come to that report once again. And not we are in a game of sports, not where the reputation of a state organization was at stake. Guwahati, Jharkhand, and such other state officials, they were about to persuade the organizing association to lodge an FIR. That's what the complaint said, the inquiry report said, and we somehow persuaded them, don't do this. Now, please come to 184.
Yes.
And the 3rd line from the top. He then said that he made series of representations to the secretary of the association for withdrawal of suspension. He repeated that he did not do anything wrong at all. He came to know that about suspension only from the website of the association. Not a single document was given to him. Sri Banerjee prayed for immediate withdrawal of suspension. Now, I have shown to your lordship on the last occasion that he was WhatsApped about the decision to suspend. Having thus carefully noticed the relevant contours of the events that unfolded, including respective submissions, the committee took upon itself to examine the complaint made against Sri Banerjee and the claim of evidence and materials and the chain of evidence and materials on record. as the subject proceeding involved of serious charges of not merely indiscipline, but also of willfully violating the regulatory prohibitive provisions of the association and charges, which tend to interfere with the basic principles of discipline and respectful behavior of a senior player representing the state of Bengal and against the credibility, image, and reputation of the association. The committee was conscious to making process in open mindset in the fundamental interests of justice and fair play within the framework of the constitution of the club. None of the members on the committee were association members. They were two independent persons who were forming the constitution of the disciplinary committee. Code of conduct and regulatory norms and directions. Then the judicial principles are quoted. Then please come to page 185, not the first paragraph beginning with the words moreover.
Yes.
When players proceed as a team to represent the state at national level, prestige, honor, and dignity of the state must have to be maintained. Duties are cast upon senior experienced players to behave in exemplary manner to teach the accompanying junior players, while predilections and the pregnant excesses of anyone must be put under proper check. Discipline serves as a watchdog in order to avoid every form of mischievous attitudes, misconduct, or any misdemeanor on the part of anyone. Even otherwise, any willful violation of the code, rules, and regulations, overreaching them by overt motives and acts requires exemplary sanctions to be dealt with, not merely to prevent such mischief from being repeated, but also to inform and warn all others of the serious consequences thereof. Not what happens if a senior player on the team misconducts himself in a manner. Not using the association, petitioner number 1 has secured a job through the sports quota. Does this give him a charter to conduct him in a manner in complete violation of the enumerated rules of conduct as not contained in the constitution? But I don't say that this has to be proved to the hilt. It can be nobody's case that in an inquiry of this nature, this has to be proved to the hilt. Now, please come to page 187. Note the penultimate paragraph of page 187.
Yes.
Moreover, the two experienced managers of West Bengal Badminton Association, none of whom have any
Page 187.
187.
Yes.
Moreover, the two experienced managers, none of whom have any animosity towards Sri Mondal or any player, immediately went to the hotel and made direct spot inquiries and confirmed what complained by Sri Rao. After interactions with the hotel personnel, their inquiry report remained unchallenged and uncontroverted. Thus, the strong probabilities to indicate that Sri Rao was either influenced and manipulated to soften his complaint, or that he all on a sudden became sympathetic towards the charge players, forgetting the basic principles of discipline. The entire stance of Sri Mondal was based on reliance of the mail dated 7 September of Sri Rao to the General Secretary. Sri Mondal neither proved how he got the mail nor produced Sri Rao to corroborate, though the team management submitted its inquiry report and deposed, confirming both in writing and through evidence what actually did take place. Thus, no proper credence could be given to the mail of Sri Rao without a substantive corroborating cogent evidence. It was only Sri Rao could have personally deposed as to what he charged and what he meant in the mail, but he was not made to appear even virtually. Additionally, Shoikot made false statement that till going to the court he was not given any document and his knowledge was only from the website of the association regarding suspension. Service of the suspension letter through his WhatsApp is on record. Additionally, his support in the falsity of Aditya's claim before the committee that the hotel management were also surprised as no complaint was made to anyone at all and they were not even aware of any incident became apparently false on the face of it. Thus, Sri Banerjee did not inspire any confidence of the committee. Sri Banerjee's avoidance of cross-examining the team management and not rebutting their evidence and the inquiry report with his witness or any cogent substantive materials despite opportunities being so provided, and further not producing Sri Rao as witness, though he relied upon his mail dated 7 September 2025, were extremely crucial as the evidences tendered and deposed by the team management remained uncontroverted. Mere denial on the part of Sri Banerjee was perfunctory. During the course of hearing, he did not challenge the inquiry report nor the evidence of the team management deposed in his presence. On the contrary, he tried to extend support to Sri Aditya Mondal's new unsustainable and false assertions that the hotel management expressed surprise as no complaint was made to anyone at all, and they were not even aware of any incident. The committee all throughout his depositions observed the demeanor of Sri Shoikat Banerjee, which demonstrated that he was trying to shield his guilts instead of coming clear with apologies and regret. His eyes and behavioral modus betrayed him completely. Had the committee put him in cross-examination, it might have been difficult for Sri Banerjee to sustain his tutored versions. However, as the role of the committee was to adjudge the statements of respective parties with neutrality based on their probative values without acting as prosecutor, the committee refrained from undertaking any mode of cross-examination. Nevertheless, the committee was conscious that the reported charges as circumscribed in the complaint and the notice of show cause are to be dealt with, and no other issues were of any relevance for consideration. But as serious charges were attributed to Sri Banerjee, a senior player of Bengal for a considerable period of time, a duty was cast upon the committee to look into his persecuted conduct over the period of times, which disclosed that in numbers of hard-fought competitive single matches, he was found to have recurring breathing problem, cramps, felt exhausted and slow reflex responses. While Sri Banerjee had lots of potential with bright future prospects, but his graph steadily went down in the competitive levels, and such downfalls were quite fast. I don't trouble your lordship not with such other observations. Lordship may straightway come to page 190, the second paragraph. Another glaring and worrying effect of the subject incident which has been brought to the notice of the committee needs to be emphasized. The All India Junior Nationals of under 15 and 17 boys and girls is scheduled to be held at Bhubaneswar between 1st December to 6th December. Expressed their hesitancies to permit their wards to stay at the allocated official accommodation of the team, and insisted that their wards be permitted to stay with them only, which the association had to permit. This is quite humiliating for the association and raises reasonable environmental and security alarms which need to be protected. Unless the regrettable and impermissible indiscipline is dealt with in strong arms with exemplary sanction, confidence and security of the junior players are bound to suffer immensely. Taking into account the preponderance of evidence so placed and weighing and balancing the entire available materials and evidence on their probative values, the committee is unable to accept or appreciate the mere escaping submissions made by Sri Banerjee. But consequently, the members unanimously concluded that the charges do have substances and reliability, therefore established on the reported charges and preponderance of reliable probabilities and materials on record read with the degree of culpability, the committee is comfortably satisfied that Sri Banerjee committed indisciplinary acts and misdemeanors by willfully violating the series of regulatory constitutional mandates of the association, and the acts and conduct so perpetrated by Sri Banerjee are also injurious to the reputation, integrity and image of the association. Not the rules are quoted, I need not trouble your lordship. Not lordship may straightway come then not to page 193.
Yes.
Assessing all aspects as detailed in the reasoning provided therefore, and after giving sincere, thoughtful considerations and detailed deliberations and analysis, as well as taking into account the evidence having reasonable nexus and harmonious credibility, based on preponderance of probative value and on the degree and gravity of the culpability and offence, the committee, by invoking Rule 12, read with the Code of Conduct, suspends Sri Banerjee from participation in any tournament or championship in the discipline held under or organized by or under the aegis of the association till 31st of March 2026, provided, however, such suspension shall not prevent Sri Banerjee from registering himself as per prevailing rules and regulatory norms or otherwise from taking part in corrective training and undergoing coaching, as suspension only relates to his participations in tournaments or champions. The Honorable Secretary is directed to communicate. Not pausing here for a moment. Not he is in a game of sports. He was representing the association, a state association. But I draw inspiration from two very recent examples in the cricketing world. But I can't name the cricketers. Not one was permanently dropped out, though not he was a very familiar face in the domestic cricket. And there was a very eminent, not a prominent prodigy who could have made to the Indian team even before not Sachin Tendulkar could have made his debut. At the age not even before Tendulkar would have made his debut appearance. But he was dropped. But they were made to undergo certain rigors of a domestic tournament so that they come back and they set an example. Now, today, I'm not trying to take advantage of 2 or 3 intricate flaws here and there will not help the cause of the sports. will not help his cause, will not help the cause of the association as a whole. And what the circumstances which had to be taken into consideration, not only for the purpose of this particular incident, but for the purpose of protecting the reputation of the association vis-a-vis the other underaged tournament participating personnel whose guardians were also not apprehensive. Not when we take a team outside the state, not we take the responsibility of various age group players, and he was an adult group player. But if this would have happened with some other, not I don't want to mention that incident, not what would have been the situation prevailing. And what he say, he has flashed out a document this way, I shall come up, Lordship may fix it for further hearing, let him not let there be not any interim order passed. Not I have also a point of maintainability of the writ petition. Not there is a judgment delivered by this honorable court in the case of not a bridge association, where the court has held that a writ petition is maintainable following the Cricket India's case, BCCI's case. But BCCI's case was delivered in the context that cricket is a national, is almost in the nature of a national sports in the country. It's widely telecast. That's why it has a public law interest involved in it, and therefore it was maintainable against BCCI. But this is entirely a private body. But I fail to understand how that judgment will apply in the facts of this case.
Yes. Could I just respond to the end?
You are appearing for?
Yes.
176.
State.
Very small condition.
Yeah.
Kindly see the second leave. With the above decision, you may prefer an appeal under Rule 16 of the Constitution by following the flow provided. Kindly turn over to page
162.
162.
Yes.
The provision of appeal, Your Honor.
Yes.
Any person aggrieved by the decision of the disciplinary committee or any office bearer or representative of a council member or a member aggrieved by the decision of the body adopted in terms of Rule 12 may seek final dispute resolution in the process of arbitration by referring the same to the president of the association within 7 days from the date or date being communicated, along with fee of ₹5,000 and a fee intermediate. Any delay in filing shall cause automatic rejection of the appeal. The president shall within 7 days thereafter select one of the independent arbitrators from the panel of arbitrators elected in the annual general meeting every year, refer the appeal or refer on notice to the applicant for adjudication in fast track process in accordance with the arbitration of 1996 with all its amendments thereto. Until final decision of the arbitrator, the decision obtained either by the disciplinary committee or the general body or PFAB shall remain operated unless expressly stated by the arbitrator by any interim decision with reasons. The council may select anyone to defend the association if necessary. The decision of the arbitrator shall be final and binding on all concerned. So my humble submission is that an alternative remedy is available. It is open to the petitioner to exercise that.
Could I just in 5 minutes, could I just respond to Mr. Mojumdar's submission in 5 minutes? Please bear with me. He admits that if there are certain, I can't take advantage of certain intricacies and come and say what is wrong, it doesn't help the sport. Please have a look at page 188 once. This is supposedly the inquiry I was a part of. A disciplinary authority discharging quasi-judicial functions, and this is the finding 188, last paragraph, please note. The committee, all throughout his depositions, observed the demeanor of the petitioner, which demonstrated that he was trying to shield his guilt instead of coming clear with apologies and regret. At that stage, they had made up their mind, had come with an apology. And his eyes and behavioral models betrayed him. One more aspect, two things I'll just show. 189, because your lordships have consistently held that you can't rely on something which is not a part of the show cause on which I have not been charged. Second, you can't take anything that is extraneous to the proceeding. Please have a look at the second paragraph. Nevertheless, the committee was conscious that the reported charges as circumscribed in the complaint and the notice to are to be dealt with and no other issues. But as serious charges were attributed to the petitioner, a senior player of Bengal, for a considerable period of time, a duty was cast upon the committee to look into his persecuted conduct over the period of time.
Yes, of course.
Of course, Mr. Majumdar, I'm sure,
Punishment.
of course. Over the period of time, which disclosed that in number of hard-fought competitive single matches, he was found to have recurring breathing problem, cramps, felt exhausted, slow reflex responses, while had lots of potential with bright future, but his graph steadily went down. This is not there in my show cause. Why have you? So what is the committee attributing me that I should have come, and before hearing my deposition, they attributed me with the guilt, saying my eyes betrayed it. And now they take into account past conduct. This line that has been added is shameful at page 190, that people are going to them and asking that boys and girls should be kept somewhere else when the person who has made the complaint has retracted it. Nobody has come forward it. One most important query, my lord, I did not mistake. As lawyers, we make mistake. My lord, may I just cite a decision on the point that your lordship had put a query to Mr. Majumdar? What is the effect? If the main complainant is not there, on the basis of which the complaint can't be sustained in law. Disciplinary proceeding initiated on the, I should have taken that, but I've learned that now. I immediately looked up the law, my lord, with the help of my juniors. A disciplinary proceeding initiated on the basis of a complaint and the complainant not produced, the proceeding can't be sustained, far less the order. In aid of that, may I just rely on this? This is a division bench judgment of our court. Page 2, last paragraph, please see. Hey, copy that. I'll reply the site. Last paragraph. There is no doubt that in a disciplinary proceeding, proof of preponderance of probability is sufficient. But in the present case, it is really difficult to hold the respondent number 1 guilty of the charge when we find that the complainant was not even examined by the inquiry officer. And then it goes on to, my lord, hold, and then certain observations are there. Hey, copy it down.
Yes. Page 4, last word on paragraph.
That's right. So, my lord, now, if I may just come back,
But Mr. Banerjee.
My lord, I understand I have to satisfy your lordship's conscience. I understand that. I had to satisfy my conscience too.
No,
because
leave aside that. See, Rule 16 provides an appeal.
Yes.
If suppose today also the court pass an order in favor of a stay, it will be total unsettled what the program has made.
No, that also. I'm sorry, my lord. Your lordship is right. Let me just rely on Mr. Majumdar's judgment that he cites to show that it can't be done.
No, not that.
It can't be a stay. The judgment records that in cases you can actually.
I am not on.
My lord.
I am on that. If suppose today the court pass an order for a stay, it is totally unsettled the program which they have made 24. Today we are on 18 or 19. 5 days. If it is and you've been allowed the total, it will be unsettled. Correct. And tomorrow you will get the order because today I am not going to the dispose of the matter on merit.
Naturally.
To be heard on merit and because it is not the case. The statement was recorded. It is on the videography. I don't think I'm not disclosing.
No, it is. I am taking this to be true and showing the defects. Yes.
And second thing, Rule 16 provides for an appeal.
Yes.
And it is the authority to prepare. If you file an appeal, the arbitrator is to be appointed. And if you got the favor in your favor, then you have a further. Yes.
Alternative remedy, your lordships have never held.
I am not telling alternate.
I understand that the program that is there, on 24th might gets unsettled because Mr. Mojumdar in the passing makes a reference that whoever was number 2 is now scheduled to go. So immediately showing that I am the one who's actually number 1. And there is a suspension.
This court cannot.
No, it sans this penalty. And I have tried to highlight how this has been done. There is clearly what meets the more than what meets the eye. The main person is not there. There is some other person who's identified later. There is no attempt by the respondent to highlight how they could rely on the third witness when he was not there. Some things have not even responded to. Who is Mr. Shoikot Mitro? And that is not a part. The respondent makes no attempt to justify it.
This is disclosed for the first time here. We shall respond.
That his identity comes later, and his version is relied on without producing him as a witness. Second, that this third witness who's mentioned, this Abhishek so and so, as in because I can't name his title, Ashutosh. I would have said Rana, but
it is better not to.
But why he is there, that is also not included. And with regard to this getting unsettled, may I just take 1 second's instruction? No one has gone anywhere. The camp is starting from today. The camp is starting from today. It's not unsettle anything, which is why I want to take instructions. Camp is from today. People go participate in the camp and the tournament starts from 24th. It will not be unsettling anything. But if your lordship is otherwise, if I have been able to satisfy your lordship, and if I may rely on Mr. Mojumdar's judgment itself, that in certain cases court can grant a stay, my entire life is going to fall apart. I have shown at least 4 instances where there is serious breach. And I understand, that the court can see that there is a little more than what is here. This is unheard of. Prithvi Shaw's example from Ranji cricket will not help. He was found partying on a video in a certain way.
Okay.
This, is different.
That's all. Not replying to the judgment, not cited at the bar, not at the last moment. Please come to page 2 of the judgment.
Yes.
Now, it is settled law that even hearsay evidence is admissible in inquiry, domestic inquiry. It appears from the available records that the respondent number 1, being a constable of Kolkata police, faced a departmental proceeding on the allegation that he robbed 10,200 from possession of one Mr. Quddus Ali by assaulting him with fists and blows and putting him in fear of instant death. A criminal case was recorded against the said constable, the respondent number 1 herein being Hare State Police Station and case number 430 of so-and-so under section 392. And the said respondent was also arrested in connection with the aforesaid criminal case. The disciplinary authority initiated the disciplinary proceedings against the respondent number 1, and the said respondent number 1 participated in the disciplinary proceedings. In the present case, departmental proceedings and criminal case are based on same set of facts and identical charges. So, obviously, depending on the facts and circumstances of each case, the standard may vary.
No, there is no difference in standard. One doesn't operate and overlap with the other.
Or subject to. If, because there is this Rao has not been examined. You are putting the blame upon this respondent, the petitioners. They could have been bring the Rao. You have not examined the Rao. Correct. If you give the consent, let the suspension be continued. Are you setting aside this disciplinary proceeding? You start giving an opportunity, examine all the witness, giving an opportunity of hearing for cross-examination and examination. Suspension will continue and to dispose of the proceeding within a certain period.
As
it is your. Because you will also get the chance of examining the Rao, he will also get the chance of examining the Rao, then that will be. If
the operation will be successful, but the patient will die.
That is the problem, because it is a game.
No, I understand what is troubling the court.
If it is
it will seem like I have won. But
now I could have been passed an order, but there is the game. We have to be some strict.
The camps are on. I'll go and play.
What can be done, Mr. Banerjee? I appreciate, but
my life will fall apart. My entire life will fall apart. 6 months.
2 players had already been emailed to the committee.
Next of the 2 players are not here, Mr. Mojumdar. You also know what
it has been emailed to me. I have received the instruction this morning.
The camp is on. I don't play for 6 months. Another 6 months trial. 1 year is gone.
Because this schedule cannot be changed.
No, so nothing has happened. And that's why I took instruction. The camp is on, Milord. I go
Camp
take
is
part
for
in
the
the
persons
camp.
who have been selected.
If what will
They are
happen
going
if
to
I play a
participate.
tournament?
Selected person.
Yes.
Which I am number one. I have been selected.
Where is the ground? Where is the
But he is not in the camp. Not his client is present in court.
This is called kindly have a see. Mr. Mojumdar has instructions from his client. Milord, client will instruct him correctly. No one has gone anywhere. It says Badminton Academy camp will be on. Coaching camp for the Bengal team on 19th. So no one's gone anywhere.
The
Milord,
names
this
have
way.
been said.
This was no, Milord, names have. This was such a serious thing that
State championship, no, national championship names have not been
names have
registered in
been
the
set.
meantime.
Milord,
What has the
the
narration say?
national camp is for camp, and then the people will go. Must attend the coaching camp. Will reimburse 3 tier 2
My
fare to
narration
Kolkata.
knows that a team is selected and then the camp is held.
Milord, no, Milord, I don't know any such thing. We go practice in Moidan, then we get selected. So I wouldn't know. I don't know, but the camp is on.
Not all 30 players will
Milord, my job is going to go. Everything is going to
his
go.
job is not going to go.
No, I'm not getting the certificate from them.
No, his
But-
job is
but
he's
my
an empress.
life is to play. I have shown enough to at least satisfy the court that there is something wrong. Milord, let me play this tournament. Please, Milord, otherwise I participate in the camp and let
Please
me
come
play.
to page 3, paragraph 3. Lord, he has secured a job under sports quota in Patna because of his exceptional
I am
talent
not.
and devotion.
I want.
This
Milord,
is
how
not getting
difficult
discharged
is
by
it-
any means.
How difficult is it for Badminton
This is
Association to
this has-
understand
This has
that
probably
I want
given
to
us some
play?
sense of
But I'm
competency
national
in
level
him.
player 1.
This has given
I
us
am
some-
rank 1.
This has given us sense
They
of
will not take
complacency
me
to
to
him.
camp. They will not. And this is how they go ahead and hold it.
Hearing concluded for orders.
Very grateful, Milord.
Extremely grateful to you.
Very, very grateful.
Concluded with regard to the interim order. Pick for orders. Huh? Pick for order तो हम ही देख.
I had a matter.
अच्छा, it is two men ना. Hearing concluded करी थी, not out मत करी. आज के
But irrespective, Milord, your Lordship has been very, very kind, given us a very patient hearing. Very, very grateful. Milord. Very grateful.
1 PM today.
Huh?
I had a matter at 1 PM.
Only for
Lordship.
interim. Take. I will take, no problem. ठीक हम देख लेंगे. 2 minute रुक जा. Yes, call the एक बजे का matter दो.
If you can take up this matter Monday, and Monday also I can do it. Monday.
What is the matter?
Since the orderly is already there, you have heard this matter. But I had a copy straw. The refund was supposed to be made.
that one.
That one.
I'll come back on Monday, my lord.
Yes, we'll come back at Monday at 1.
I tendered apology. I could
एक
not be
बजे
there.
वाला matter है ना? Monday रख देना. Monday एक बजे.
Since it's your lordship's lunch time, so let it
You should not disturb me.
Monday एक बजे खाली है तो देख.
or 12:30 anytime. 12:30 is okay also.
দুটো করে থাকে তবে ট্যাক্সে আটকে থাকে
Monday 1 PM.
I'm grateful, man.
वो फाइल नंबर इसको भी भेज दो ऑफिस में, इमीडिएटली ऑफिस में भेजो, हम साइन कर दें.
এই রিপোর্ট ফাইল করেছিলাম আমরা রিপোর্ট ফাইল করেছিল স্টেট দিয়ে রেখেছে রিপ্লাই দিয়েছে পরে হবে এক্সটেনশন করে আপনি সৌমদা ছিল আপনার ভ্যাকেশন এমনি চলে এসছে নোটিশ দিয়েছে এই চলে এলো নোটিশ মেনশন
Yes, call the man.
নাম প্রদীপ
1 and 2 এটা তো না আপনি দুটো বেরিয়েছে
Chambers से आते हैं। Who is for the state? You do one thing. Nobody is for the state. You do one thing. I am directing you this Daruwala matter.
Yes,
That
sir.
on judgment.
Yes,
You forward to the AGI.
But I had written previously. I'll do it again.
Forward that, and I will keeping the matter on Monday.
Okay,
Correct. You are also not informed this prior to that paragraph. And I am dictating, then I have gone through that. That is to be considered and also to the state authority.
So, my lord, I should communicate that order to the state.
State, as per the request made by the court, I am forwarding it for your consideration
My lord.
to the state to this state as well as the AGI. Correct. And it will be listed. The petitioner is directed to forward the order. What is the case number you are having? Forward the order in the case of Daruwala. What?
Maja Daru, my lord, diary number 60063.
What is the name? What is the name?
Maja Daruwala. MS.
Give the name. Give. Yeah.
No, it's transferred case criminal number 1 of 2013.
Forward the copy of the order passed by the Honorable Supreme Court in the case of MS Maja Daruwala, dated 16th May 2025, to the ASGI as well as the learned advocate appearing for the state. Full stop. The state is both the ASGI and the state is directed to take instruction from the concerned authority. List the matter on Monday. Monday कोई टाइम खाली है देखो. ग्यारह बजे नहीं 12 बजे फुल है. खाली है 12 बजे at 12.
My lord.
Thank you. Today itself you forward this.
My lord. Case number 2. Grateful.
Lordship, I appear on behalf of the petitioner, Lordship. Lordship, the interim order is due to expire today. Lordship, the similar matter was taken up yesterday. Lordship, may I hand over the order, Lordship?
Fine. Where is the order?
Lordship, this is a similar matter which was taken up yesterday, Lordship.
For the other side.
Lordship, I have...
For the state matter.
Extension of interim order.
This way.
As per the prayer made by the counsel for the petitioner, the matter is listed as to be mentioned in the supplementary list for extension of interim order. Interim order is extended till 22nd of January 2026 or until further order, whichever is earlier. List the matter on 26th of January 2025 under the heading head conversion.
Vice. Payment of finance. Fix.
फाइल मंगा लो.
एक ही मैटर नहीं, एक ही मैटर.
हाँ. उसमें ऑर्डर करना है ना, कॉस्ट टाइटल नहीं है। अच्छा उससे देख। Yes, next. Grateful.
You appear for the writ petitioner.
Yes, your Lordship, I am for the response.
On last occasion, Lordship directed the respondent number 3, the station manager, to produce the report based on which they have disconnected the electricity meter.
My Lord, from the outset, my Lord, I must submit one thing. There is some mistake on the part of my clients. So far, disconnection is concerned. But if your Lordship hear the entire matter, then your Lordship, I believe your Lordship with me. My Lord, on last occasion, your Lordship directed me to produce the original letter and, my Lord, the register of disconnection.
On the basis of this, you can disconnect it.
Yes.
No, no proceeding, nothing, no order.
No, my Lord, I'm simply, my Lord, I leave it to your Lordship, my Lord, so far that part is concerned. But your Lordships kindly consider what is the prayer of my learned friends. My learned friends prayed for refund of security money, which, my Lord, after permanent disconnection, we will refund it. And, my Lord, main aggrieved, my learned friend is to effect new connection to the private respondents. If your Lordship is of the opinion that yes, effecting of new connection is bad in law, we are ready to disconnect. If your Lordship is of the opinion that we should reconnect the earlier connection, we will reconnect, my Lord. We don't have any other of the parties. Don't worry. So, my Lord, my largest friends, my Lord,
Yes, what is the prayer?
prayer C is refund of security money. So, from the prayer C, it appears that he has not grievance any disconnection, and more or less that apart, your Lordships kindly consider one important aspect. 2008, consumer has died. February 2008. My learned friends clients will not never given an intimation.
Died in the year 2008.
Maybe now died.
This is the wrong submission.
No,
sir.
Yes, I will come to you. That
Yes.
in morning I also stated.
My Lord.
I will not appreciate the both advocate can start argument. Then I will go and you argue and take the judgment.
My Lord, after death of the consumer, he should have given an intimation. Look, he has died. Kindly transfer the connection in the legal layers which they have done. That has not been done. The moment the private respondents being the, my Lord, the maybe I don't take brief on behalf of private respondents. His husband was a tenant. He was in possession. He has supplied all the documents that we have already, my Lord, produced. We have effected connection on the basis of the documents which he has supplied. So, my Lord, my learned friends is not after effecting connection, it has came to our knowledge that the consumer has died from the local inhabitants also. That we have disconnected.
What is the submission?
Lordship, it is evident that the respondent number 4, that is the private respondent, are not in clean hands, and the doctrine of clean hands squarely applies in a mortis. And the first prayer is the permanent disconnection of the electricity meter.
Of which your mother's?
No, Lordship, the new meter, which the meter of Suniti Machi, which she has applied for.
Have you applied? Have you applied for the disconnection? Have you applied for the disconnection of the electricity connection of the Suniti Maji?
I'm not my
Who are
prayer.
you?
I'm the owners of this property.
Correct.
In
You
this
are the owner. Correct. The Suniti Maji has applied for the disconnection.
We have raised objection to it. We have raised objection to it, and they are liable to disconnect the meter of Suniti Maji.
Let me understand. Let me understand. You are the owner of the property. Suniti Maji is in occupation, illegal occupation of the property or illegally occupied.
Absolutely, Lordship.
Correct. And Suniti Maji, by way of an application, disconnected the electric connection of the your mother.
Mother-in-law.
Correct.
Mother-in-law.
But the electric connection was provided in the name of your mother, that has been disconnected on the application of
Criminal impersonation. Absolutely.
So, that is okay. Now what you want?
I want the disconnection of the electricity meter which Suniti Maji had applied for and had obtained illegally. That is evident from their submissions. So, and the second is, Lordship, the protection from the police authority which we have approached earlier twice, but we haven't get any support from the police authority regarding these grievances.
What grievance?
That they have applied, without intimating the petitioners, they have encroached my land and disconnected my meter, as well as they have committed house trespass and housebreaking as well. So these are the offences, and the respondent number 3 clearly violated section 163 of the Electricity Act, where they are entitled to
Suniti
inspect.
Maji is in occupation on the premises or not?
Yes, Suniti Maji is in occupation.
You take appropriate step for her eviction. What the writ court will do here?
Lordship, eviction is the civil dispute, but regarding the electricity meter,
That's what I'm asking here. Why you not understanding? That's why I'm asking. What is your grievances here?
My grievance is she had obtained electricity meter illegally.
So
by
and you applied for
disconnecting my
discon-
meter.
That's the first question you ask, whether you applied for the disconnection of the Suniti Maji meter.
I am not entitled to apply for. I can raise objection. That I have raised already.
Who are you?
We are the owners.
Owner. Your case is the Suniti Maji illegal occupy
Absolutely.
and illegally obtain the electric connection.
Absolutely.
So you will not apply for the electricity department for the disconnection of the electric connection.
We have applied for. Lordship, please come to.
After going from here, I have to go to the mental ward. For the last 15 minutes, I am asking where is your application for disconnection of the connection of given in the name of the Suniti Maji.
Lordship, kindly come to paragraph number.
Paragraph number, where is your application?
Annexure. I'm indicating that, Lordship. I'm indicating it. Lordship, kindly come to page number 59, annexure P12.
59.
I have the translated copy, Lordship.
Arpan Halda.
I have the translated copy.
Yes, give the copy.
This is the copy.
Conducting proper inquiry, take steps so that the electric connection is severe. Yes. So what has happened now? They have not considered this.
They have not considered
So your one grievances is that this electric connection is to be disconnected.
Disconnected.
And next
And next grievance is to give us the security deposit, which they haven't.
of your
paid.
mother's
Absolutely,
connection.
Lordship.
That is to be treated as a permanent disconnection and the refund is to be made.
Absolutely,
Whatever
Lordship.
the amount is
And-
pending.
Yes, Lordship.
Yes.
And
Next.
the third is, Lordship, the wrong which they have committed, mainly the respondent number 3 is concerned, in collusion with the private respondents. They were in conspiracy, and the collusion that is evident from the record, and there is a clear violation of the rules that are enunciated in the Electricity Act. They have clearly violated it. I'm trying to indicate, Lordship.
Yes. So what you want?
I do want the permanent disconnection of the electricity meter.
These are the three grievances.
These three grievances.
Okay. Yes.
My lord, I am for the private respondents.
Yes.
It is an admitted fact that the private respondents are in occupation of the property. Whether illegally or legally, the civil suit is pending, that will be decided thereon. So far as the connection of the 2 meter,
Who has filed the civil suit
they have filed the civil suit.
against you?
Yes, my
What
lord.
is the prayer in the civil suit?
Eviction, my lord.
Eviction.
Eviction.
Okay.
Now, so far as the connection is concerned, my lord, the private respondent number 426 were residing there. Initially, the connection that was there in existence was disconnected by the petitioners. Later on, the private respondent number 4.
No, you have applied for the connection.
Yes, I applied, supplied the requisite documents, and they supplied us the
What
connection.
document you supplied for?
On the last, all the gas connection, the documents,
In your name you applied for.
yes, my lord, in my name. That happened much prior to the disconnection that they are alleging.
But how you applied for?
By submitting the documents, my lord.
Submitting the document with regard to you are the daughter of the.
No connection with that. That is what I'm indicating, my lord. The respondent number 4 has no connection with the disconnection that they are alleging. That they are alleging, that they are blaming on the respondent number 4, the petitioners.
No.
We have applied for a connection. We have got a connection, and all this happened much before the disconnection.
Applied for the connection on what ground? As a occupier or as a legal layer?
As a occupier, my lord.
Where is your application? Show me as you occupier.
Application, my lord, those are already been submitted on the last.
That I find it. That's why I'm asking you. I am giving an opportunity.
Yes, my lord.
You don't.
I
have already gone through the document of the authority.
Those are the documents we submitted, my lord, before the electricity.
But in the application, what you have submitted?
That we need a connection since there has been disconnection by the petitioners.
Where is the document?
Well, that last occasion that was with file original.
Those are that
original file was lying with the record.
That is the only application made by the respondent number.
The original file ta was. Yes. The first is application. Thereafter, my lord, is Aadhaar card, PAN card, and then, my lord, voter card, and then, my lord, Indian gas connection documents, and then, my lord, bank passport, savings banks accounts within the name of the same, mentioning same address.
What is
that you have considered an effect
page number 60, annexure P13? They have admitted. Page number 60.
Just a minute. And so this is the application.
That is the only application made by respondent number 4.
With regard to the disconnection, what do you have?
We have nothing to say. We have nothing to do with the disconnection, my lord.
Who has applied for?
I have not. Respondent number 4 has not applied for it. The signature is also mismatching, my lord. I have even indicated that on the last occasion. That is the vernacular language signature that is there on the PAN card of the respondent number 4 is totally mismatching, my lord. It's visibly distinguishable from the signature that is there on the application that they are relying on and blaming us on.
That is not your signature.
No, not at all, my lord. Kindly.
Disconnected.
There is some, so far my part is concerned, my lord, there is some mistake that I have seen. That's why, my lord, from the very outset, I submit before your lordship. My lord, if your lordship is of the opinion, we will reconnect. We have no, my lord,
So you want the reconnection or refund charge?
I want the disconnection as well as the refund charge.
What disconnection?
Disconnection of the meter.
Cannot be. He is the occupier, he is entitled unless he is evicted from the property in question, he is entitled for the electricity.
As per larger.
They have admitted.
Maybe.
They have admitted.
What admitted?
Page number, come to page
What
number
admitted?
60.
Tell me.
That they have admitted, though you have stated her as your deceased mother. They respondent number 4 criminally
Which page?
Page number 60.
That is
annexure P13, as well as this second report by them.
Page number
60. Annexure P13.
60.
They have done it contemporaneously.
On 15, an objection letter was received for reference so from applied for permanent disconnection, existing connection having which has been named.
It is with regard.
Correct.
It is with regard to disconnection of the.
Correct. That's why this court has called for the record. Call for the record. They are having only one document, that is the letter. Correct. This letter. So this letter then he is denying that. He is denying that.
Lordship.
The signature.
Absolutely.
If you any, I will give liberty. If any objection, you file a police complaint before the
Lordship, the police authority is not cooperating with us for the investigation.
By the side there is a court. Inaction of the police. By this after this wall, there is a court for the inaction. Correct.
Lordship, my simple prayer is the disconnection of this meter.
Has filed the present application. Praying for. filed an application for disconnection of the electric connection provided to the private respondent, namely, in whose name it was provided?
Private respondent 4, 5, and 6.
All three. In the
No,
three
one.
names.
The name of private respondent number 4.
In the name of this, the name of Suniti Maji, the private respondent number 4. He submits that. See, the private respondent number 4 has obtained the electric connection fraudulently by showing that she is the daughter of late
Pushparani Chakraborty.
Pushparani Chakraborty. Though she is not the daughter of Pushparani Chakraborty. Full stop. The further grievance of the petitioner is that the private respondent number 4 has made an application before the WBSEDCL for disconnection of the meter connection, which was provided in the name of the grandmother.
Lordship.
In the name of
you, Lordship, kindly, I'm relying on this judgment.
In the name of the grandmother of the petitioner. And in the application which the private respondent has requested the WPSCDCL for disconnection of the electric connection. In that application, she has narrated that she is the daughter of the deceased. What naam diya na? Kya bola? Pushparani. Another prayer of the petitioner before this court that the electric connection which was provided in the name of the grandmother of the petitioner, but the WBSTDCL has not refunded the security deposit. The security deposit is to be refunded. Full stop. Full stop. Learned counsel for the full stop. This court has called for the original record from the WBSTDCL with regard to the application filed by the private respondent for disconnection of the electric connection, which was provided in the name of the grandmother of the petitioner. The authority has produced the file wherein it is found that one application was filed on 22nd of May 2024. What is the name? In the name of Suniti Naji, for permanent disconnection of the meter connection bin consumers ID number 153024259. Full stop. The authorities have also produced the original file wherein the private respondent has applied for grant of electric connection. In the said file, it is found that the original form submitted by the private respondent along with the connected document, that is Aadhaar card, election identity card, gas connection card, and the copy of the suit pending before the copy of the case filed before the subdivisional executive magistrate at Barasa. The grievance of the petitioner that the private respondent has by mentioning that she is the daughter of the deceased Pushparani Chakraborty has applied for disconnection of the electric connection, which was provided in the name of Pushparani Chakraborty. This court considered the original application filed by the private respondent number 5. The learned counsel for the private respondent number 5 has denied that the signature appearing in the said letter is not of the private respondent. This court find that only on the one paper application the authority had disconnected the electric connection of the Pushparani Chakraborty, but no proceeding has been drawn. Now the private respondent number 4 has taken that the signature is not in the name of the private respondent. No signature appearing in the said application is not of the private respondent number. Accordingly, this WBSCDCL is directed to forward this copy of the application submitted by the private, alleged to have been submitted by the private respondent number 4 to the concerned police authority. And if within a period of 1 week from date, and if any complaint is received by the concerned police authority, the police authority investigate the matter whether the private respondent has applied for disconnection of the electric connection in terms of this letter dated 22nd 5/2024. Full stop. And to take appropriate steps in accordance with laws. As regard the grant of electric connection, this court find that Suniti Maji, that is the respondent number 4, has applied for the electric connection in her name by disclosing her identity in the said application, incorporating the documents. And this court did not find any contrary document that Suniti Maji has misrepresented before the authority that she is the daughter of the, what is the name? Pushparani Chakravarti. The petitioner did not, it is not the prayer of the petitioner that the electricity connection which has been disconnected is to be restored. The only grievance of the petitioner that the electric connection which was in the name of the Pushparani Chakravarti was disconnected, that's may be made as a permanent disconnection, and the security deposit
As well as the restoration also. New application can be filed by the petitioners as well.
That we always will.
That
Always.
Permanent, and the security deposit made by Srimati Pushparani Chakravarti at the time of grant of obtaining the electric connection may be refunded.
And what about
In view of the above, the electricity connection, in view of the above, the WBSCDCL is directed that the electricity connection which was provided in the name of Revarani Chakravarti, which was disconnected, be made as a permanent disconnection, and the security deposit may be refunded to the petitioner with the petitioners within a period of,
as your lordship,
2 weeks from the date of receipt of this order. Full stop.
With interest.
As regard the disconnection of the electric connection of the petitioner, respondent number 4 is concerned, this court finds that the petitioner have already initiated a civil case before the appropriate civil court, and the same is pending for eviction of the private respondent. Admittedly, the private respondent is in possession of the property in question. Thus, it is settled law that the illegal occupier is also entitled to get an electric connection. Thus, it is not proper for this court at this stage to pass any order for disconnection of the electric connection. But it is made clear that getting an electricity connection will not create any right, title, interest of the private respondent over the property in question.
Grateful to you.
Just indicating that the judgment which I have relied upon,
My lord,
that squarely applies in our case, Lordship.
My lord, may I be permitted to take back the original records?
The original records is written back to the learned advocate appearing for the WBSCDCL.
I'm grateful to your lordship.
WP is disposed.
Grateful to your lordship.
दोनों फाइल दे ये भी ले लो. Next.
Number 19. Milord, I appear for the writ petitioner, Milord. This is, Milord, against termination of a works contract, Milord. And Milord, I was given, after termination, I was given a notice that if you don't vacate the entire premises within 15 days, you will be thrown out with the aid of police. I had, Milord, therefore mentioned the matter, Milord, in view of this urgency, Milord. I have served the respondents, Milord. 2, Milord, by speed registered post and 2 of them by hand, Milord. The first respondent being the GP, Milord, they did not accept because they said, unless leave is granted by the court, we will not accept without 48 hours notice. But they are, Milord, really not the real respondent. The other respondents perhaps are here, Milord.
Who is your appearing?
I'm for the state authority.
Here.
I have not received any copy because they have served it by email, through email to them in the evening only. And we have just got the email copy. We have not received any instruction as of now. So if your lordship kindly make it after vacation. Or
I will record your submission. You undertake that he will not evict.
Yes. don't give effect to this letter that you, because today they'll throw me out, they say.
Till
Your
8,
Lordship,
9,
already
10,
a
whatever,
reason
as,
order has been
as
passed.
per your convenient, I am fixing the date.
Then your Lordship make it next week.
Next week.
Yes, your
26,
Lordship.
26.
On Monday.
Monday, there are so many matters.
Then on
Yes,
Tuesday, your
what
Lordship.
what is the matter? Where is the notice? Mr. Singh, where is the notice?
Kindly allow me to use the supplementary affidavit. This letter was wrongly annexed. Page 10 of the supplementary affidavit, where they say that if I don't vacate within 15 days, I shall be thrown out with the aid of police. Let this be stayed, let them come.
Construction of proposed Rani Rasomani Green University near Tarkeshwar, Hubli. What has happened? You have not completed the work.
The project, I had to construct a G+7 educational institute.
Correct.
Now, this contract was for 1,000 odd days. In 2022, I was given this work order. I had to construct this building pursuant to a design given by them. This is under the terms of the contract. They give me the design only this year in February. And then they extend my time. The extended time is 20 December 2026. Within this time, they issued 2 show cause notice and now terminate. Against these 2 show cause notices, I prefer a writ. Then this is second round of litigation. I preferred a writ challenging those 2 show cause notice. The court did not interfere because in any event termination was not there till then. The matter went up till Supreme Court. Supreme Court said, go back, ask them to consider our representation. I should show the Supreme Court's order that if the payments are not made, the RA bills are not clear, designs are not given, how could I? Court said, all right, these are contractual dispute. I am directing them to consider your representation. After coming, meanwhile, when the writ petition was pending, they terminate the contract. This is against termination. And also, secondly, the Supreme Court had said that consider their representation because what the point that we had raised were plausible, and the court said.
When the termination was done?
Yes, termination happened on 18th July 25. Now,
not challenged that.
Earlier I had not challenged this. Now I have challenged the termination because termination happened.
July.
Yes, so this is the termination that I have challenged now.
This is
yes.
The July order you are challenging.
Yes. No, because the Supreme Court had said that you consider the representation. So this process of representation and their consideration, their rejection of my consideration representation has happened only on 19th of November 2025. So 2 orders are under challenge: the termination of the contract and their rejection of my representation, which was rejected on 19th of November 25. They reject on 19th of November and then they issue this notice and say that if you don't vacate within 15 days, we'll throw you out with the aid of police. But I shall show from the face of records, the termination is contrary to their own terms of the purchase order, and further, the contract is subsisting. They give me design in February, they give extension in May, and in July they terminate, Well, it's still 1 year to complete the work. I said you make payment because under the contract you was.
Where is the termination order?
Yes, the termination letter, will find at page 244. P20. I had to trouble the court because if I don't move this, 244. They should not throw me out before the writ petition is heard.
There is no this arbitration clause.
No arbitration clause. There's no arbitration. I have to go in suit, and before that, if I am thrown out,
Whereas you were served with the so-called notice in this regard, and this office, itna, which has not been replied to the satisfaction of the engineering charge. Which department? PWD?
Yes, Milord.
So what about the measurement has been taken in terms of the 18 July?
No, nothing has been done. May I suggest this, Milord? Their last letter by which I had to move this hurriedly, Milord. If I don't vacate by today, they'll throw me out. Let this be fixed on the reopening day, Milord. I shall serve my friends there. But in the meantime, let them not throw me out.
Now, sir. At
Now,
present,
sir.
yes, my lord.
So you are ready?
No.
What I propose to do, if suppose, what you propose to, there is also the time limit is there. So I will request you not to pass any, not to evict, not to take any action in terms of the letter dated 5th December. Let the matter appear on 7 or 8.
Lord, this project is the public.
That's why I'm telling. That's why I'm telling. Now we are on 19. We are on 19. I am fixing on 7th or 8th.
Yes.
But
Oh.
tender issue.
Lots of kindly see the already fresh tender already issue.
When is the opening date?
Already issue.
Work order issue.
Already issue.
This
Not only
project-
that, my lord. The huge amount is the
I have invested, my lord, from 2020.
Lordship, 98.
You are not challenge this new tender notice.
No, my lord, because I have challenged my termination.
No, you're.
If I participate in the tender, then I waive my term.
That's why you're not challenged.
No, no, because I have challenged the termination itself, my lord. And if I succeed, this subsequent tender will automatically go. And if I participate, then I accept the termination. That's the difficulty. My lord.
You could have been challenged that
Lordship.
tender notice which has been issued. You are not challenged the tender
My
notice.
lord will kindly appreciate. My lord, I have.
Your tender was cancelled.
Yes.
After the cancellation of tender, they have published a new e-tender or whatever the tender notice. Correct. Some third party you are not participated because you are challenging.
Yes.
But you are also not challenged that e-tender notice or tender notice whichever issued for the remaining work of the project in question. So now if the work order is issued to the third party, so how correctly the third party has to execute the work.
No, my lord, kindly appreciates, my lord. I have, my lord, invested in this property since 2021. I have constructed a portion of the work allotted to me. Meanwhile, this arbitrary termination has come in, despite, my lord, the Supreme Court directing them to consider the issues that we had raised. Now, to bypass everything, my lord, they, my lord, issue a work order to someone else, my lord. This has to be subject to the outcome of this.
Supreme Court has passed an order.
Yes, my lord. The Supreme Court's order is dated 10th October 2025.
10th October 25.
Yes.
The order.
Order, my lord, you'll find it page 397. So to bypass everything, they issue a new tender, and my lord, I'll have to. This is
397.
397, P32, my lord. And then, my lord, to make my writ petition infructuous, I am threatened that I'll be thrown out of the property. Last volume.
Supreme Court ki
Bolo na je.
Yes, nothing.
Division bench had said, my lord, kindly look at the division bench's order, my lord.
The division bench order.
Yes, my lord. Page 316.
16.
Sorry. 392. So I'm sorry, my lord, 392. And the relevant portion, my lord, will find paragraph 13 of the judgment. Paragraph 13 is at page 395. Although we are not minded to interfere with the order impugned and the decision of the learned single judge, the disputed questions of fact are involved and therefore writ petition are not maintainable. Nonetheless, we request the authorities to consider and decide the contents of the letter of 4th July 25 by passing a reasoned order.
Correct.
This is what Supreme Court also said. You decide.
Correct.
Now, my lord, they reject it.
Correct.
And, my lord, without any reasons. So this order is also under challenge.
4th July.
4th July representation was rejected by them.
That you have challenged that the 4th July, the contents of the letter of 4th July passing a reason.
Yes.
The 4th July representation is connected with which order of the cancellation?
19th November, which is at page 403. 19 P34, my lord. This is without, my lord, considering the issues that we had raised. Complete non-application of mind I can show, because for this I'll have to show my issues that I had raised in my representation and how those have been dealt with, my lord. They reject this, they reject my representation. This is at page 403, my lord.
Yes.
I am against this letter as well as my termination. Both.
1911-25.
Yes, my lord. This is their order rejecting my representation.
No, that's nice. Initially, your 4th July, you have made a representation.
Yes.
Against which order? 4th July.
4th July was again my representation to them.
Correct.
To allow me to work, give my payments, because unless payments are made, I cannot continue with the construction. And it has raised series of issues.
Pending that representation,
They terminated. Yes. Court said, you please dispose this off. Now they have disposed of. Normally, the first round of litigation did not have the termination, that the termination was not in existence. So I had to raise this in the, so this writ petition has the termination under challenge and this representation's rejection, my lord. While these two is pending, my lord, now they give this letter and they say you leave, otherwise we'll throw you out by the aid of police. So all that I was humbly submitting, my lord, will hear me out. But in the meantime, let us just not become infractuous, my lord. That was my only submission, my lord. This is why I had mentioned it yesterday, my lord. And I can take, my lord, through all the documents and the purchase order and show as to why the termination itself is wrong, my lord. And contrary to, on the face to the terms of the purchase order and on the face of it, my lord. I've invested huge sum of money in this project.
But you are not challenging the second tender notice.
I would kindly appreciate.
Second tender notice, the third party interest is accrued. So what can be done?
But before that, my interest is there, since 2021.
But you're silent over there. The second tender notice.
If I succeed,
you succeed. You could have been challenged that.
Lordship.
If you're not participating, you could have been challenged for staying up that. But you're not challenged that.
Very well, what I can do is, I shall challenge that also in this. Kindly allow me to do that. But in the meantime, let this not become infractuous.
Challenge now. After when the tender was when tender notice was issued, the second tender notice was issued.
Lordship 21 me.
Huh?
Second notice was after.
When the second tender notice was issued.
Lordship, after the order of the writ court, thereafter writ petition already failed, my lord. Thereafter, on the basis of that writ already tender already issued.
Come with a good case.
According to the
kindly
division
protect
bench-
in the meantime, my lord.
Lordship, according to the division bench order.
Already second tender party applied, work order issued to the.
My lord, kindly appreciates, my lord. Today, my lord, I have invested huge sum of money in this project. If I am thrown out, my lord, nothing.
Go for the damage. Go for the damage.
Lordship, kindly see the page number 404.
My lord, Supreme Court had, and the division bench had directed them to my lord,
They are directed, but in the meantime, they have
8 crore
already initiated the
paid.
process for the second tender, and second tender is concluded now.
can they bypass the directives of the Supreme Court, my existing right in the asset that I've invested so much of money merely by issuing a second tender.
Party interest has accrued, so it is validated.
You are already representation already considered.
I have been instructed that work order has not yet been issued in favor of the third party. They may have been identified, but the work order has not been issued. The tender has been floated.
Participated, no?
If I participate, then I go by to this.
Number 404.
Very well, still, I can still do that. I can still do that. But in the meantime, this has to be decided whether the termination is correct or not. Kindly, this will result in
that will decide it. If you got in your favor, then you will get the benefit in the damage. Nothing can.
Then allow me to, after vacation, allow me to place this writ petition at least.
So what do you want?
Kindly let them not throw me out till the opening, so that I can come and.
Representation already considered.
May I, if I can show from the face of record that termination is contrary to terms, kindly.
On merit you come.
Yes.
I will hear on merit, but today I will not pass any order. In interim order, I will not pass. Come on the merit, I will hear. Let the affidavit complete, but sorry.
So, my lord will kindly fix it on reopening day in that way. But I'll come and satisfy. But I have to.
The petitioner has filed the present date application challenging. What you are challenging? This order?
The termination letter.
Termination letter, where is it?
Termination letter is at page 244, annexure P20, my lord.
244. Challenging the order of termination of the contract of the petitioner dated
18 July 25.
Dated 18th of July 2025.
And the decision dated 19th November 25.
And where is that?
Page 403.
And the decision taken by the respondent authorities in terms of the order passed by the passed by the Honorable Division Bench as well as the Honorable Supreme Court. Therefore, challenge the Resolution of it dated 19/11/2025 in terms of the order passed by the Honorable Division Bench as well as the Honorable Supreme Court. 19/11/25. 19/11/25. The petitions also challenged by way of supplement has also disclosed the communication dated 5th of December 2025, wherein the Executive Engineer PWD Hubli Construction Division, Chowk Bazar, Hubli, has directed the petitioner to arrange for removal of all unused construction materials and machineries, if any, from the work site within 15 days from the issuance of memo, and if the petitioner failed to vacate the same, authority will take appropriate action in accordance. Counsel for the petitioner submitted the petitioner has initially made a representation for consideration of the case of the petitioner, but the same was not considered. Accordingly, the petitioner has filed the writ application before this court. The said writ application was dismissed by the coordinate bench of this court by an order dated 11 September 2020. Being agreed with the said order, the petitioner has prepared an appeal, and the appellate court has disposed of the appeal by requesting the authorities to consider and decide the representation submitted by the petitioner dated 4th of July 2025 and to pass the reasoned. Being agreed with the order passed by the Honorable Division Bench, the petitioner has preferred an SLP before the Honorable Supreme Court, and the Honorable Supreme Court has disposed of the SLP filed by the petitioner on 10th of October 2025 without interfering with the order passed by the Honorable Division Bench and requested the authorities to consider the petition filed by the representation filed by the petitioner as early as possible. Good. Now the authorities have passed the order on 19/11/2025, rejecting the petition. In the meantime, on 18th of July 2025, the contact of the petitioner also been cancelled, and now the authorities are directed the petitioner to vacate the premises in question. Counsel for the petitioner pays for an interim order restraining the authorities for giving any effect or further effect to the communication dated 5th of December 2025, wherein the opponent's authorities directed the petitioner to vacate the premises within a period of 15 days. Per contra, an advocate appearing for the respondent submit that the contact with respect of the petitioner has been cancelled on 18th of July 2025. The petitioner has not challenged the order of cancellation. In the meantime, petitioner has challenged the order of cancellation now in the present date application after the period of 5 months. The further submitted in the meantime, the responsibilities have already rendered, and the work order has been issued to the third party for completion of the remaining work awarded to the petitioner. If further submitted, if at this stage any order is passed and the work could not be completed, which has been awarded to the third party in terms of the second point. At the learned counsel for the respective parties peruse the materials of the court. This court finds that Initially, this court find that the representation made by the petitioner was duly considered by the authorities and the same was rejected by an order dated 19/11/2025. In the meantime, on 18th of July 2025, the the work order was cancelled. And after the cancellation of the work order, the authorities have issued the first tender notice for execution of the remaining work, and as per the submission made by the respondent, some third party has already been selected for completion of the remaining. Considering the above, this court find that the third party interest. This court find that the authorities already cancelled the tender of the petition on 18th of July 2025. The representation filed by the petitioner was already been disposed of, rejecting the request of the petition on 19/11/2025. Now the third party interests are already been accrued. Thus, this court did not find any IFSI material to pass any interim order. Accordingly, interim order is refused.
Also, my appearance is kindly regularized.
Yes.
My appearance is kindly regularized.
Appearing for the state, the appearance of
AGP
the petition director to serve the copy, na?
But the new tender will be subject to outcome of this writ petition. My lord, kindly at least.
Already tender.
Yes.
Already work order issue.
Sorry, come with a good case. Come with a good.
I'm deeply.
Lost. Come to
19. 20. Yes.
I am for the petition, Your Lordship. This is my affidavit of service, Your Lordship. Your Lordship, the matter relates to a tender procedure, Your Lordship. In the Alipur Zoo, Your Lordship, for the last, from the year 2024 till now, Your Lordship, there are two types of tender, Your Lordship. One is for an ice cream kiosk and another is for food purpose. As per the norms, Your Lordship, all the tenders and all the stalls should be in a designated area, not beyond that, Your Lordship. I have participated in the tender, Your Lordship. From the year 2024 till date, Your Lordship, 8 tenders has been called, Your Lordship, and every time it has been cancelled, citing the reason administrative purpose. That is the sole purpose. Why? The second, what is I'm submitting before Lordship is that there are certain vendors, Your Lordship, because if you have to have a ingress and egress inside the zoo, Your Lordship, there is a designated area, and the government charges us, Your Lordship. We are going to supposedly pay for it, and we are designated area is given. We run our business. Now, the fact remains that if Your Lordship can call a record from the concerned authority, Your Lordship will find that there are multiple vendors who doesn't have a license. They might have participated in tender 2000, 2 years back, 3 years back, but still they're in operation. What I'm submitting is that for the last, from 2024 till date, I have given 5 examples where the tender has been called and cancelled, citing there is an administrative purpose. No definition has been given. On the last occasion I participated, they gave the same reason. There is administrative purpose, tender cancelled. I am at a representation. They again has called a tender, but no one knows the future of it.
Where here now?
My simple prayer, Lordship, there should be an investigation why this is happening, because for the last 8 tenders, citing administrative reasons.
So you are continuing with the tender?
No, I participate. They're not. Lordship, I am participating, but once I'm participating, the one process is done. They said it's cancelled, administrative purpose. So I am my simple.
What right you are having?
Your Lordship, for the last 8 from 2024 till now, if they're calling for a tender, they're cancelling it. I am at a representative. Let that be considered as well. Because why, Your Lordship, this putting this question to myself? This is the government revenue.
Once they have placed the tender, but subsequently they came. No, it is not required.
And that's why, Your Lordship,
whether the court can impose condition. Yes, you have to complete the tender process.
Your Lordship, that's
no. The court can impose condition to the authority to complete do the tender process.
Your Lordship, this is a public money involved, and I have participated.
What for public money? What have they have taken the amount from you?
No, Your Lordship, but they are technically allowing the unauthorized person to run the show. How can that is possible, Your Lordship? Putting this.
Who is running the show?
Your lordship,
Who is
the,
running? Where is the private party?
because your lordship, I have participated.
What is your grievances? Your grievances is that 4-5 times they have
8 times, your lordship.
8 times they have issued the tender notice.
And citing the reason,
Subsequently, they have
cancel it.
withdrawn that.
Administrative purpose, cancelled.
So what the court will do now?
Your lordship, again they have called for it.
The cause of action.
I am participating, your lordship, because now citing a reason, they should have a logical conclusion to it, because it cannot be that for 2024 till 2025, tender will be called multiple times and they will never give a reason for that. I am before your lordship to kindly ascertain that why this administrative purpose will be done, because my submission is that on averment I have said that there is an excess going on where there are certain public, your lordship, they don't have a license to operate.
Have they allowed any persons to continue with this install or whatever it may be?
They're not disclosing that, your lordship.
Disclosing, there will be stall. You can identify there are stalls.
Your lordship, if they are not allowing me to participate in the tender, and how can that? That's why initially I submitted to your lordship letter.
What is the tender for?
Tender is for two purposes, your lordship. One is from ice cream kiosk, and other for the food.
That's why ice cream kiosk and food.
Yes, your lordship.
Food stall.
Yes, your lordship.
Ice cream stall and the food stall will be appearing in by open eye if
Yes.
they are running the business on
Yes, your lordship.
business in question. So whether any person is running the business over the
Yes, that I cannot disclose. That I have no information. That they will be in a better position, because I am putting an allegation that if there is, your lordship, kindly appreciate one thing.
He is running the shop at present.
That the authorities can say, your lordship.
That is your allegation where
Yes,
some
that I
person
can
is-
show.
Some person is running the running the ice cream parlor without and they have allowed without the process of law. Where is that?
That is in my representation at page.
Not represented. Show me the pleading.
Yes, sir.
What is the case you have made out?
That is there, your lordship.
Para 6 onwards.
There are various miscreants who are illegally occupying the space inside the offset geological garden and disturbing the harmony. Go to the public interest litigation. File a public interest case for the public interest litigation.
But this is more of a RTI than a litigation.
The petitioner has the grievance of the petitioner in the present writ application that the respondent authorities time and again issuing the tender notice for ice cream, for food and ice cream stalls at which place? At which place?
Alipur Zoo. Alipur Zoo, your lordship.
Alipur Zoo. But
It's zoological garden, Alipur, your lordship.
But every time the authorities have cancelled the tender process with the on the ground of administrative reason. Administrative reason.
Page 29 annex that, your lordship. Page 29.
On the ground of administrative reason. Full stop. Counsel for the petitioner submits that the petitioner has made a representation to the authority to consider the representation of the petitioner and to complete the tender process so as to enable the petitioner to be participated in the tender process. This court find that though the authorities have issued the tender notices, but subsequently the same has been cancelled due to administrative reasons. Thus, this court did not find any reasons to did not find any merit in the writ application. Accordingly, the writ application is dismissed. However, the dismissal of the writ petition will not prevent the petitioner to take to challenge any further cause of action in future.
Deeply understood.
What is the So disposal note. Rejected, let the matter appear on 10th of Let the matter appear on 12th January under the new motion.
I am appearing for the state of the I am appearing for the state of the
Good.
You then.
Oblige with
Yes, Mr. Sarkar, which matter?
Next matter, my lord.
Boundary wall is over. Yes, what is any urgent?
Well, may I believe lordship to mention urgent matter, my lord? Sir, Chulsi matter.
Which 21?
21, lordship.
I appear for the private respondents, my lord. I think there is some not so sure. Your lordship will see the array of the state respondents. whether your lordship would take up this matter, determination wise. I'm a bit.
Land record.
Land.
Yes, Mr. Sarkar.
Well, land and police. Both.
We are
Neither I am having land nor I am having police.
Well,
Without police, without land.
Lordship, he's trying to confuse anyway.
I'm not trying. I'm just showing the cost title.
My lord, this is to Didevan. The petitioner is making a first private township in West Bengal in 15 acres of land.
I have some issues on maintainability if I run it from.
This court is having the determination. How?
Well, there is a paragraph 42 and 43.
What is the prayer?
Kindly see the phrase, my lord.
Erect and mark the cost of
Paragraph 11, lordship says at page 3, paragraph 11 on.
Copy them.
Demarcation of a land will take place without land determination.
Well, it is a multifarious cause of action. So,
So you choose to quote number 25.
Joinder of causes of action.
It's better to go before a smiling judge.
Interlocutory court, joinder of causes of action. This has become, my lord.
So,
Paragraph 11, 12.
paragraph 11 and 12 very clearly later.
30. 12, 30. 11 to 30.
Yes.
Paragraph 13 in particular says.
There's no overlap. Both don't have. Both is not. There's no overlap.
Releasing, I am ready.
Yes.
So what happens when a big project comes up, vultures pumps
Releasing
in?
it. Go to the appropriate court. I don't think it's
Lordship, can you give me a minute? There is a multifarious jurisdiction involved. Everybody will throw me out, but 2 days left. Where shall I go? Lordship, can you consider this? And after all I say that there is apprehension of breach of peace. So let and the government has published in its website that they will demarcate land upon payment of charges specified in the notification. All I say, let them demarcate. And I have a boundary dispute allegedly with my private response, they allege to be. And my lord, the anti-socials are coming into my project, stopping the workers and all. There is a apprehension of breach of peace, one thing. Second is, if they demarcate the land, my lord, at my cost, they are.
This court cannot pass an order to unleash the land of the retreat.
Consider the judgment. It is there. It says that.
Lordship has seen that in a given case, there may be overlapping of the subjects as classified by the REIT rules. There may be in given case an overlap of matters related to panchayat and land, or between a residuary matter and land. There is such type of reputation as dominus lightus would be entitled to choose between the overlapping groups. Correctness of classification of reputation in a group under the REIT rules would depend on facts and circumstances of each case. So,
either police or land. One of police or land. With the greatest of respect, my lord, perhaps.
This is nothing to do with land. It is land survey. Land survey doesn't fall under land, my lord.
Appellate side list देखे बोला नहीं.
Land survey, land comes under Land Reforms Act, and we are asking under the Survey Act. Lordship, all I say, Lordship, look at the prayer straight away. At page 25.
Two courts of concurrent jurisdiction, you can approach one court, but with the greatest of respect, this court doesn't have jurisdiction either over land or police. Except police. Except police.
Excluding police.
Determination is excluding police. Okay, anyway, my objection may be recorded. We'll deal with the matter on merits. There's no difficulty.
Well, when we have no answer on merits, we take the point of jurisdiction. Of course, my lord, I don't blame my learned friends here. The state has to answer.
It is better. I am releasing. I am giving a liberty to mention Monday on the appropriate court. This is better.
Lordship has seen that we can choose.
But under which
Yeah, either land.
It is not, my both are needed. It's not that. Lordship, look at the circulars. Circulars are by the survey department. Survey department doesn't fall under land. Survey department doesn't fall under police.
Survey department functions under the land and land reforms department.
And Lordship,
Is
and I've
under the land department and is regulated and managed by the land department.
yes, of course. Land department, this is under Bengal Survey Act. They'll be acting.
Why I am saying the authority is the district. Well, kindly come to their cost title. They have added.
Correct. That's all that I said. Kindly see the cost title.
Directorate of Land Revenue Services. Kindly come to cost title, respondent number.
Kindly see serial 1, Principal Secretary, Land and Land Revenue.
Revenue.
Petitioner is not having the this court is not having the determination in the present date application. Accordingly, the writ petition is released from the list of the case and list of this court with the liberty to the parties to mention before the appropriate court having the determination.
Grateful, Madam.
Malad, this is the law under which they will function. This is
I'm for the
Arey,
state, Malad.
release
release করে দিয়ে একটু দিয়ে
Yes,
Malad, this is the law under which they will act.
कॉपी तो देखते नहीं
Actually,
स्टेट रिपोर्ट लेके आया
इतना जल्दी बिना रिट हियरिंग में
बिना एडमिशन
কপি দিয়ে দিন না সুবিধা হয়
না আমি দিতে পারবো বলে দিন
Malad, the state has come with a report. May I have a copy?
What an ex.
The state has come with a report. May I have a copy, my lord?
So the writ is admitted, the state has come with a report.
Yes,
That's not what happened. Cost matter, your lordship would have seen, state has come with
Well,
a
how a private respondent is so worried, so
My
worried.
Before appropriate court, you file it.
If you can give a copy, it will be easier.
You as a friend, you can give it. Not
Without order, I can't, man.
not at the order of the court. Yes.
My lord, may I have the leave, my lord, to mention this matter, my lord. That is my lord. This matter is, my lord, that is very important, my lord. That is on 31st of October, that was heard by your lordship, my lord. And a lot of litigation has been done. Due to that reason, at least subject, let it appear as to be mentioned on Monday, my lordship, please. Matter is, my lord, 31st of August, that was heard by lordship, my lord. And the alleged count number 1 to 6 were brought on arrest, my lord. They requested by lordship that they shall file the affidavit by 10th of November, but they failed, my lord. Due to that reason, my lord, I am suffering, my lord. At least let it appear to be mentioned on Monday, my lord.
Preparing for?
Petitioner.
It's a contempt matter. Contempt matter laga do.
Lordship can make it not under the heading to be mentioned, my lord, on Monday. That is item 38 today, my lord.
Correct. It will come as a contempt matter.
Contempt matter, that is appearing under heading.
What is the urgency?
Urgency is, my lord, that, my lord, we are getting nothing, my lord. They were brought on arrest on 31st. They were directed, they failed on 4th occasion to file any affidavit compliance, my lord. That is the certificate.
After vacation, I will see.
My lord, at least subject.
Come after vacation, I will see. Yes, call.
My lord, may I be permitted to mention, my lord, item number 23 of my lord's list today. My lord, the interim order is expiring today, my lord. This is a defamation suit where my lord had 23, my lord. My lord, the interim order is expiring today, my lord. The defamation suit, my lord, where
the other side?
My lord, I have given notice. My lord, Mr. Kakrani is here.
Though the matter is listed as item number 23. 23?
Yes, my lord, 23.
23. Mr. Learned Counsel for the petitioner prays for extension of the interim order. According interim order is extended till 22nd of January 2026 or until further order.
My lord, will kindly post it after 26th, my lord, after 26th of January, the interim order.
20th January.
My lord.
Well, may I have your lordship's kind leave
And
to
my
mention
lord, the matter
for
will appear,
extension
my
of
lord, on.
well, may I have your lordship's kind leave to mention for extension of interim order, my lord, item numbers 71 and 72 of your lordship's list, my lord.
I have for the respondent.
Mr. Ray is leading me, Your Lordship.
71
and 73, my lord.
Ah.
These are, my lord, section 9 applications, my lord, heard by Your Lordship, my lord. My lord, Mr. Ray, perhaps, my lord, was there on, my lord, the...
But I'm still there, my lord. I'm opposing, my lord.
Yes, my lord.
Not the exchange.
Now, my lord.
71 and 73.
73, my lord.
So in both the interim order is there.
No, my lord, 73. In 73, the interim order was, my lord, subsisting.
Yes, Mr.
My lord, I'm opposing. I'll leave it to your lordship, my lord.
Though the matter is listed as item number 73, but the learned counsel for the petitioner mentioned the matter for extension of interim order. Learned counsel for the respondent raised objection for extension of the interim order. So find that the petitioner is already enjoying the interim order, and for the interest of justice, the interim order is extended till 22nd of January 2026 or until further order, whichever is earlier. Let the matter remain in the list.
And I was only beseeching your lordship only once, my lord. May I just point out, my lord, if I'm not there in the first week, my lord, kindly allows me an adjournment, my lord. I wouldn't be there.
But then in that, even,
week,
my lord, kindly
first
keeps it,
week,
my lord, in the second week of, my lord, January.
Can I fix the matter for hearing in the February?
Yes, my lord.
That will be better. So hearing
Yes,
can,
yes. Yes, yes, my lord. I'm ready for hearing, my lord.
Let the matter up.
My lord, it is, my lord, our section 9 application which your lordship was hearing, my lord. So we have completed our submissions, my lord, so far as, my lord, the petitioner is concerned in, my lord, both the applications, especially in AP 91. My lord,
In the month of February.
if your lordship kindly, my lord, keeps it, my lord, sometime, my lord, in second week of January, my lord. Well, thereafter, my lord, in that even, my lord, kindly extend the interim order also.
Yes, yes.
Very
Interim order till that day.
Very.
Both the application be remain in the list.
Very well. Very well.
Grateful, my lord.
Appear on 9th February 2026 at 3 p.m.
I'm so grateful.
Very grateful.
Let this matter be appeared along with AP Com 91 of 2020.
And one of the interim order is also, my lord, extended. Interim order, my lord, which is in AP 90, item number 73, my lord.
That's extended.
That is
The
also.
order extended till
But you see, cogently also.
I'm so grateful.
The interim order is expiring today.
Grateful.
Matter also, I was bringing it.
Only one indulgence, my lord.
It can be fixed, your lordship.
My lord, only one indulgence, my lord. Item 22.
Item
Identical.
given, your lordship.
Identical.
Be fixed, your lordship.
Today, I will take today itself.
My lord, identical prayer for item number 13 and 14.
Item number 14.
14.
14.
The interim order is
Prayer
expiring
made by
today,
the
my
council
lord.
for the which matter?
My lord, this is that matter wherein my lord was pleased
So
to.
the prayer made by the council for the plaintiff interim order is extended till 23rd of January 2026 or until further order, whichever is earlier, except respondent number 6 and 7.
My lord. My lord. My lord.
Can be fixed, your lordship. If it is favorably also, let it be.
Other side is not there.
My lord, we are.
Your Lordship, I am for the defendants 13 and 14 in item number 14, Your Lordship. If the interim order is extended, I don't think I have a problem. Your Lordship can fix the matter.
Let the matter appear on 11th of February 2026 at 3 p.m. Interim order extended till 11th February 2026.
Obliged, sir.
Only one indulgence, my lord. Appellate side, item number 22. My lord, this is against the serious fraud investigating agency. My lordship was pleased to take up the matter on 11th of December. My lord, the SFIO was required to file the lookout circulars. Yes, item number. This is the last order that was passed. Yes, my learned friend is appearing for the SFIO.
Appellate side.
Yes, appellate side. My lord, only difficulty is, my lord, I am, my lord, making endeavors to travel, but only, my lord, because there are subsisting lookout circulars, my lord, I am not being able to. My lord, that's the obstacle. My lord, today, my lord, I know there is a paucity of time. My lord, Monday we can come back if lordship will kindly accommodate us on Monday, my lord.
See, I will put the date as a urgent motion, but I can't assure when it will be
No,
taken, because see, all the matter I'm fixing urgent motion, I am not reaching up to 20.
My lord is reaching. Sometimes I am not reaching.
That is your luck. That is your luck.
My hard luck, lordship, because that day, Miller, what happened, I was waiting for in this honorable court since morning. All of a sudden, the matter was then I missed the bus, lordship. So, Miller, I have no issue.
No.
Whatever my lord's diary.
Now, before vacation, then now the slow, because all matter is taking up.
By any day, my lord, if it can be.
इसको ना 20 Monday urgent motion में रख दो. Urgent motion আছে
But anyway,
वाला matter
हैं?
वाला matter 2 बजे
but some precedents in your lordship's list, if they,
में 10-15
great.
With your kind leave, Lordship, I understand there's a fixed matter and I may not get a turn. Item number 8 of my Lord's list. It's only for clarification, Lordship. I had mentioned the matter. My Lord had said because it's a probate matter, it's better if I come up with an application. Lordship, the death certificate, the probate was granted by my Lord, but the death certificate of the person who died, the Hindi translation changed his surname, Lordship. So he's Birendranath Moitro, but the translation done, it is written Moikhya. I have annexed the death certificate and the translated copy. I would only praying for a clarification order and I could make the corrections in the department in the translated copy. The probate has already been granted. I'm getting stuck in obtaining it, Lordship. It's an uncontested probate, Lordship. Already granted, only receiving is getting stuck because of this, Lordship. GA1, Lordship.
Monday to be mentioned.
Grateful, my lord. Grateful.
Lordship, this is a suit for eviction. My interim order is expiring today. I've given notice to the other side.
Suit before this court.
Lordship, this is a part heard matter, specially assigned.
It is not in the list.
It is there. Item number 63 of today's list.
You are for the plaintiff.
Yes, Lordship, I'm for the plea.
So the matter is listed as item number 63.
Yes, Lordship, 63.
But learned counsel for the petitioner plaintiff has mentioned the matter on the ground that the interim order is still today and prayed for extension of interim order. In view of the submission made by the counsel for the petitioner plaintiff, the interim order is extended till 27th of January 2026 or until further order, whichever is earlier, let the matter remain in the list.
My problem.
Yes, call the. You will get only 10 minutes.
Yes, my lord, we'll make progress, my lord. That's my lord. Now, my lord, I had shown your lordships, my lord, the appraisal note, my lord, chart in the reply, my lord, to the show cause notice.
Chart
my lord, the chart this is what we had given yesterday.
You show us the chart from the show cause.
My lord, in the show cause notice, my lord, your lordship will kindly come to, my lord, the reply, my lord, to, my lord, the show cause notice.
Yes.
My lord, we had, my lord, set out the chart at page 128, my lord. My lord, writ petition, volume 1, page 128.
Yes.
Now, my lord, what I had, my lord, tried to impress upon your lordship was that, my lord, the 2 years, my lord, for which, my lord, they say that we are in willful default, my lord, because, my lord, we diverted funds to our group companies, my lord, the entire thing, right from, my lord, 2014-15 onwards, my lord, right up to 2017-18, my lord, they had been disclosed in our annual accounts. My lord, accounts were appraised by the consortium of banks, and the appraisal notes specifically, my lord, said, my lord, that our position, my lord, was fully acceptable and recognized these investments, my lord, as strategic investments, because, my lord, we are into, my lord, the business of building infrastructure. For each project we have, my lord, we set up a special purpose, my lord, vehicle. Now, my lord, I want to show your lordship now, my lord, the appraisal notes themselves. My lord, kindly take, my lord, the appraisal note of 2017-18. My lord, I'll show your lordships, my lord, first. Page, my lord, 198.
Second volume, though.
My lord, this is volume 2, page 198.
Yes.
Kindly come to, my lord, page 213.
Yes.
My lord, your lordship has, my lord, the heading, my lord, item, my lord, 13.
Details, yes.
Details of intercompany transactions, investments, if any. Answer is yes. If yes, whether our bank facility was used for the purpose. As on 31st March 2017, the investment and loans and advances in associate subsidiaries was rupees 65.19 crore and rupees 23.21 crores respectively, which has reduced from 75.98 crores and rupees 35.61 crore as on 31st March 2016 respectively. All these investments and loans and advances extended towards associate subsidiaries are strategic in nature and is considered acceptable. Now, Millard, kindly come to Millard. What about this? Millard, kindly come to page 234. Now, Millard. 234. Millard, kindly see, Millard, the heading 33, comments on. Now, Millard, your lordship says default / willful default and any other unsatisfactory features in conduct of accounts with us / other banks on institutions or institutions. The conduct of the account is satisfactory. There is no instance of devolvement of letters of credit and invocation of bank guarantees ever. So, my lord, even under willful default, there is specific attention, my lord, being drawn. My lord, the bank says, my lord, it is, my lord, fine. Yes. Now, my lord, kindly come to, my lord, the appraisal note for 2016-17. My lord, it starts, my lord, at page 299. Lordship will find. My lord, this is the lead bank, State Bank of India.
Yes.
And, my lord, your lordships will find, my lord, EMC Limited process notes of working capital assessment. Kindly come to 311. Third volume, my lord, volume 3, 311. Millard, this is their note, Millard. Details of, I'm sorry, Millard, 311. Details of intercompany transactions / investments, if any. Yes, if yes, whether our bank facility was used for the purpose, though the investments and loans and advances in associates, subsidiaries, JVs, joint ventures as on 31st March has increased by 26.42 crores. However, this is strategic in nature and is considered acceptable. Then, Millard, kindly take page 331. Or do we show this? Yes, Ram, my lord, kindly have a look at, instead of 331, first, my lord, 324. My lord, this shows knowledge, item clause 4, my lord, your lordship will kindly take.
Yes.
4 and 5, my lord, I want to show your lordships. Change in investments in group companies, others. The investments in group companies has increased from so-and-so to so-and-so for this financial year. Then comments on sundry debtors beyond 6 months. Present position in financial year so constitutes so-and-so. It has increased by so-and-so in financial year on year-on-year basis, which consists mostly retention money of completed projects. The reason for such increase in debtors exceeding 6 months is some of the major projects of the company have been completed in 2016, but retention money is generally realized after a period of 6 to 12 months as per contract terms. Well, now kindly see, this is usual in case of a EPC contractor, because our business is EPC, engineer, procure, and my lord, construct. Now, my lord, kindly see 6. Loans and advances to group companies. The loans and advances extended to associate subsidiaries has increased from so-and-so to so-and-so. Overall increase in investment loans and advances in associates and subsidiaries of so and so and so and so is strategic in nature and is considered acceptable. Then, my lord, what? Now, my lord, one other, my lord, because there's specifically, my lord, on McNally Bharat, there is, my lord, your lordship will find, my lord, others, if any, because this has been made, my lord, a particular ground, my lord, in, my lord, the show cause notice. EMC has made a strategic investment of 142.88 crores in McNally Bharat Engineering by availing long-term loan from IFCI Limited in order to gain substantial synergic benefits coupled with enhanced ability to provide integrated engineering, electrical and turnkey solutions for its customers. No objection. Now, my lord, page 331.
Yes.
In fact, my lord, 330, if your lordship kindly starts with, comments on
Yes.
borrower default, willful default, and other unsatisfactory features in conduct of account with us, other banks, institutions. The conduct of the account is satisfactory with our bank. Payment of interest is regular, and there are no devolvement of LCs and invocation of bank guarantees, so and so. However, sometimes there is delay in payment of interest with some of the lenders, and on few occasions there were instances of LC devolvement with some of the lenders in the consortium. Such delay in payment of interest was due to occasional mismatch in cash flow in general and delay in realization of projects in Bihar due to flood and political unrest in Jammu and Kashmir in particular. The situation has now changed and cash flow has since improved. The conduct of the account has also improved since then. No issue regarding diversion. Now, my lord, kindly take, my lord, page, my lord, 386. My lord, this is part of, my lord, the appraisal of 2015-16, which starts from page 370.
Yes.
Then, my lord, kindly have a look, my lord, at clause 6 at the bottom. Loans and advances to subsidiary companies have decreased by rupees so and so, from so and so, so and so, so and so, etc. Then, my lord, at the bottom, all these advances to its subsidiary companies are strategic in nature and in line with the stipulations made by the bank. Then, my lord, kindly come to page 388, my lord.
Yes.
My lord, the last 5 lines, my lord, after, my lord, the funds, my lord, investments in subsidiaries, etc. Kindly, my lord, see, my lord, last 3 lines. With increase in business volume and increase of loans to related parties by 15 crores, there is no diversion of short-term funds for long-term use. Position may be considered as acceptable. My lord, then 404 also your lordship will find. My lord, just above the table, the overall increase in investment is compensated by infusion, etc. and condition so and so is investment in associates to be capped at 20%. This is the lead bank, my lord, conditions which are being dealt with. Then, my lord, kindly come to 1415, which starts at 443. Then at, my lord, page 451, kindly, my lord, take 451 to further expand its, my lord, the third para. To further expand, lordship has that, my lord, in its global presence, company has established 3 new subsidiaries in Dubai, Singapore and Hong Kong. Dubai subsidiary was already in operation and subsidiaries in Singapore are expected to start shortly. During the last financial year, company has also taken over Quattro Rail, who are specialized in railway signaling and electrification, and one existing running power grid approved tar manufacturing unit in Raipur. So, my lord, expansion of business. Then, my lord, kindly come to 459. Yes. Then, my lord, kindly see EMC continues to invest in smaller units, both domestic and foreign, with similar business interests during last year from cash accruals of the business. EMC has acquired, my lord, all that is, my lord, mentioned here. And, my lord, lastly, my lord, your lordship will find that during current year, where is that one?
Next, 460.
And, my lord, at 460, my lord, your lordship will find in, my lord, last three lines. In current year, long-term sources are estimated to increase. During current and next year, there is no diversion of short-term funds envisaged for long-term uses. Position may be considered as acceptable. And, my lord, just as an example, my lord, that's there in, my lord, all, my lord, the appraisal notes. My lord, kindly take page 198 once. Lordship will find, my lord, in the second last row, my lord, of volume 2, my lord, page 198. My lord, second last at the top of the letter.
Yes.
My lord, second last row, second last column, IDBI Bank, my lord, is, my lord, shown. IDBI Bank Limited, IDBI. Lordship has that.
98, 198.
198, my lord. My lord, at the start of the letter, there is a table.
Yes.
My lord, it's a SBI letter.
Correct.
My lord, it starts with Allahabad Bank, Punjab Bank. Kindly come to, my lord, the fourth row.
Yes.
And, my lord, come to the second last column.
Yes.
In the consortium, my lord, IDBI is also present.
Yes. Good. Yes.
Now, my lord, so 3.5 and, my lord, this was, my lord, annexed, my lord, in the reply to our show cause note, our reply to the show cause notice, and, my lord, which was not considered at all. Now, my lord, kindly come to, my lord, the master circular once. Volume 4 starts at page 558. My lord, of 1st of July 2015.
Yes.
Now, my lord, kindly take the definition, my lord, of willful default. My lord, clause 2 at 561. My lord, it's guidelines on, I'm sorry. Guidelines on willful defaulters. Definition of lender, unit, and willful default. Kindly come to willful default 2.1.3. A willful default would be deemed to have occurred if any of the following events is noted. The unit has defaulted in meeting its payment repayment obligations to the lender, even when it has the capacity to honor the said obligation. So, my lord, they are solvent. Instead of, my lord, paying, my lord, the lender, having the capacity to pay, they are not paying. Then, my lord, B, the unit has defaulted in meeting repayment obligations to the lender and has not utilized the finance for the lender from the lender for the specific purposes for which finance was availed of, but has diverted the funds for other purposes. Now, my lord, kindly have a look at 2.2 because they are, my lord, on diversion of funds. 2.2, my lord, the term diversion of funds referred to in paragraph 2.1.3b above should be construed to include any one of the undernoted occurrences. My lord, they, my lord, base their case on C, D, and E. Transferring borrowed funds to the subsidiaries, group companies, or other corporates by whatever modalities. Then D, routing of funds through any bank other than the lender bank or members of consortium kindly mark, my lord, the words, without prior permission of the lender. And my lord, E, investments in other companies by way of acquiring equities, debt instruments without approval of lenders. Now, my lord, what has been, my lord, argued, and my lord, the point, my lord, which has been taken is, please forget a breach of principles of natural justice. This is a case where the order of willful default is like a judgment on admission. Now, my lord, why do they say so? Because, my lord, it's an admitted fact that, my lord, we have given funds to, my lord, group companies, including McNally, my lord, which I pointed out to your lordship, which is the main subject matter of the show cause notice. Now, here, my lord, I wish to, my lord, deal with this, my lord, issue. First, my lord, is the basis of this, my lord, are two sanction letters. My lord, one of August 26, 2018, and my lord, the other is of October 18, 2017. My lord, kindly have a look.
First letter dated?
26th August 2016,
Yes.
which your lordship, my lord, will find at page 32 of the affidavit in opposition.
Yes.
Kindly have a look at, my lord, the date. August 26, 2016. Yes, my lord, kindly come to, this is the sanction letter of IDBI. Kindly come to, my lord, page 40, 40, my lord.
Yes.
My lord, it says, my lord, other terms and conditions, kindly come to D. 2, my lord, D. The company shall utilize the sanctioned working capital limit for intended purpose only and shall not utilize, kindly see D, for extending loans to subsidiaries or associate companies or making any intercorporate deposit and any other purpose. So they say, look, you have violated this. Therefore, you're liable. Now, my lord, the important thing is, my lord, that I could deviate from this. Your lordship has seen, my lord, your lordship will see, my lord, first, my lord, before this, my lord, this condition can't stand in the way because, my lord, we had, my lord, if your lordship sees the investments, they are before this sanctioned letter, my lord, which is at page, volume 1, page 127. This is again, my lord, a reply to the show cause notice.
Yes.
My lord, other than, my lord, the fund, my lord, of 0.37, your lordship seen, my lord, the table. My lord, if all the investments, my lord, had been made, my lord, prior to, my lord, 1718, other than 0.37 crores, that's 37 lakhs. Lordship sees the table, my lord.
Yes. Total 0.37
is only in 1780. Everything is before the sanction letter. So my first submission is, reliance on this is wholly misplaced. To start with, it doesn't find, my lord, place in, my lord, the order. Second, it's introduced in the affidavit. Third, my lord, clause D could not have applied to, my lord, loans, my lord, given, my lord, prior. Number 2, appraisal notes have shown your lordship. My lord, these, my lord, diversions, if any, my lord, have been, my lord, found to be acceptable and recognized, my lord, to be for the benefit of the company. Now, my lord, kindly come to the next sanction letter. My lord, page 43, my lord, of, my lord, the affidavit in opposition. My lord, kindly come to, my lord, page 49.
Yes.
My lord, 9, the company should obtain, my lord, clause 9, my lord, other terms and conditions. The company should obtain prior approval from the lenders before making
Investigation.
any further investments in group company subsidiaries. Again, my lord, if your lordship goes to the chart, my lord, it's only that 0.37.
Yes.
And my lord, this is also in the appraisal note, which I showed your lordship. Again, my lord, same point. But my lord, more importantly, my lord, kindly have a look, my lord, at, my lord, which I showed your lordship, my lord, the circular, master circular. My lord, page, my lord, 562, volume 4 of the writ petition.
Yes.
Now, my lord, investments in other companies by way of acquiring equities, debt instruments without approval of lenders. Now, my lord, very important thing is the circular itself, my lord, does not use the expression prior.
Investment in other companies by way of acquiring equities, like debt investments
Without approval. It doesn't use the word prior. My lord, the previous clause, kindly look at D, routing of funds through any bank other than the lender bank or members of consortium without prior permission of the lender. So the word prior is not there. My lord, my main point is you have given permission by the appraisal note. You have given approval by the appraisal note. Now, my lord, this is supported, my lord, by the law as well. My lord, my lord, what you've given, just escorts. Yes. Now, my lord, kindly consider the decision, my lord, in, just let me do it, no. My lord, 1986, one Supreme Court cases, 264. '86, 1, 6 SCC, 264.
Yes.
LIC versus escorts. My lord, kindly take paragraph 61 and 62, my lord. My lord, the Foreign Exchange Regulation Act, my lord, had, my lord, certain similar provisions. Now, my lord, kindly come to paragraph 61 first, my lord. From what has been narrated above, one of the principal questions to be considered is seen to be whether the Reserve Bank of India had the power or authority to give ex post facto permission under section 29(1)(b) of the Foreign Exchange Regulation Act for the purchase of shares in India by a company not incorporated in India, or whether such permission had necessarily to be previous permission. Now, my lord, kindly see. We do not propose to refer to any dictionary to find out the meaning of the word permission, whether the word is comprehensive enough to include subsequent permission. We will only refer to what Sir Shah Suleiman, Chief Justice of the Allahabad High Court, said in Shakir Hussain and Chandulal. Ordinarily, the difference between approval and permission is that in the first, the act holds good until disapproved. So, my lord, we are concerned with the master circular here. Master circular uses the word approval. If I have done it, my lord, it should be disapproved immediately and not approved in the appraisal note. So, my lord, what does it say? Between approval and permission is that in the first, the act holds good until disapproved, while in the other case, it does not become effective until permission is obtained. But the permission subsequently obtained may all the same validate the previous act. So, my lord, whether permission or approval, my lord, for ex post facto, my lord, it could have been validated. But for approval, my lord, where, my lord, the master, because I have to be declared a willful defaulter under the circular. Circular says without approval. That approval means, my lord, it's when the act is done, unless disapproved, it means you have the approval. And here there's an overt act on their part in the appraisal note.
Who will disapprove?
My lord, the bank.
So disapproved when they have declared as a willful defaulter because it is disapproved.
But before, when the transaction happened,
That is
I disclosed to them.
okay.
They had an appraisal of that transaction.
So you're
Correct. Your Lordship, absolutely. After having done that, there's no question, my lord, of then saying, my lord, that I am, my lord, a willful defaulter. My lord, I could have understood accounts had not been given. Or, my lord, there was in the first appraisal, they said, sorry, I disapprove of this. And immediately issue me, my lord, a notice to show cause. Now, my lord, I'll cite, my lord, one decision, my lord, of the Delhi High Court, my lord, which is reported in 2024, SCC Online Delhi 1516. My lord, identical situation, appraisal notes. And my lord, the court said, sorry, you can't declare them a willful defaulter. You have approved.
So your argument is that once the appraisal
Correct.
report which they have accepted, subsequently you cannot.
Correct.
Then you will.
Because, my lord, then, my lord, it was, my lord, approved, found to be acceptable, not classified as diversion. I showed your lordship comments on willful default. None. And, my lord, that approval, there was no disapproval when disclosed to them. So, my lord, as per the law approved by the Supreme Court, my lord, the act is valid unless disapproved. And immediately, my lord, they, my lord, accepted. And these are all old loans, which are showing, my lord, an investments from 2012.
Okay.
Got it? My lord, kindly take 2024 SCC Online Delhi 1516. My lord, may I indicate the para numbers, my lord, first? Para 132, 134, 135, and, my lord, 156 and 157. My lord, kindly have a look at 134.
Yes.
Sorry, 132. My lord, it's print page 52, my lord.
Got it.
The learned counsel for the respondent bank has contended that MBIL did not take prior approval before making the investment in its subsidiaries. This court is not impressed with that said argument. As discussed earlier, the respondent bank and other lenders were always aware of these investments. No document has been brought to the notice of this court wherein the lender banks raised any objection to these investments at any stage. On the contrary, the FRS of lender banks appreciated the nature of these investments and found them to be potentially financially sound. Further, the question for seeking prior approval could only arise, etc. Then, my lord, 134, the identification committee and the review committee of the respondent bank has held that the investments in subsidiaries triggered a shortage of capital and therefore act of investment falls in the diversion as per RBI guideline. Now, my lord, kindly note here, no such finding in this case. We are on a better footing. Then, my lord, 135. Learned counsel for petitioner contended that the aforesaid observation is totally misconceived and ignores the contents of so and so, etc. My lord, then, my lord, kindly come, my lord, write to, my lord, the bottom of that paragraph, last 6 lines. Thus, according to lender banks, the investments at the time when made were strategic, had growth potential and expected profits. However, when the investments did not yield profits due to various factors, they were subsequently categorized as diversion, siphoning. Such an approach cannot be countenanced in any, then my lord, that's borrowed funds, etc. Then my lord, kindly come to my lord 156, which is my lord the main one. Main, my lord, paragraph which I wish to rely on, 156 and 157. In the present case, the lender banks were aware of the investments made by so-and-so in its subsidiaries. This fact is part of the documents leading to the finalization of the CDR scheme. The investments were treated as strategic with growth potential and expected profits. The investments were found to have been made from cash surpluses. Lender banks did not find these investments as diversion or siphoning of borrowed funds. Lender banks placed MBIL in class B so-and-so, which cannot be assigned to it if there's diversion. They found no occasion to order a forensic audit either before finalization or after. Lender banks, therefore, never treated the investments in subsidiaries as an act of diversion or siphoning, either during finalization of CDR scheme or after its failure. In view of the aforesaid reasons assigned in the impugned order passed by review committee as willful defaulter and therefore is quashed and set aside. Now, my lord, here what is our case? First, the constitution is bad. I've shown your lordship. Second, my lord, in any view of the matter, the order, reasoned order, has not been passed by the committee. They just confirmed the decision of the identification committee. Third, there's complete non-application of mind. My lord, their observations are the submissions of the dealing group. It's not even of the identification committee. Correct. Now, my lord, I had replied to the show cause notice to my lord, the identification committee. They had not dealt with it. I had pointed that out, my lord, in my representation to the review committee. My lord, giving, my lord, my responses to the show cause notice. They were, my lord, not dealt with at all. There's, my lord, nothing, my lord, to show, my lord, that this has been dealt with. In fact, my lord, there are 2 portions of the order, my lord, which I wish to show your lordships. My lord, page 556, 555 and 556. My lord, volume 4. My lord, yesterday, my lord, I had pointed out clause 5.
Yes.
My lord, where, my lord, because it's a cut paste and no application of mine, my lord, dealing group, my lord, in response to our letter, second line, correct, conveying the decision so and so. Then, my lord, kindly see, last sentence of that subclause. No additional justification have been provided by them. Our justification has not even been considered. Then, my lord, kindly come to, my lord, next page. First paragraph. WDRC carefully examined the contents of the written representation received in response to the order of the Willful Defaulter Committee dated January 11 and observed that the written representation have not brought out any new fact, law or material that has the nature of changing the decision of Willful Defaulters Committee of bank to declare them as willful defaulter. The response does not comprehensively cover all the grounds on which proposal for declaration was based, and further contents are not supported by facts and record. In view of this, after thorough so-and-so of the records, in response is of the opinion that promoters, etc. Now, my lord, with the greatest of respect, my lord, this is not, my lord, how the jurisdiction is to be exercised. JAR developers specifically said Supreme Court that the representation that we give, my lord, fully considered, my lord, and my lord, here, my lord, it's not even, my lord, considered at all. Anything else? My lord, I think I have concluded, my lord. I'm grateful, my lord.
Thank you.
So there are total 5 petitions. Mr. Mukherjee has addressed your lordship on item number 1.
Yes.
I will trouble your lordship for item number 2 and 3, and Mr. Sen is there for 4 and 5.
5 is Mr. Dotto. Mr. Ayushi Dotto is leading me for 5, which is an additional point we have. Other points are the common points which are
In my other one matter, the interim order is to be extended. This is item number.
Just
4.
let this order. Learned counsel for the petitioner in WPO 424 of 2024 is concluded his argument. So respondents will give their reply to all together.
Yes.
Let the petitions complete. Full stop. Let the matter appear. क्या होएगा? Three? 20 January. 22nd January, 3 p.m.
My lord, except 20th, 21st and 22nd of January, any day.
So let the other part, Mr. Sen, continue.
So your lordship is giving any
20 and 22nd.
20 and
You will not be there.
I will not be there.
I shouldn't take long because Mr. Mukherjee has made exhaustive submission, my lord. So lordship shouldn't give too much of time for all of us, my lord.
Particularly Mr. Bose.
3rd and 5th February.
Very well.
3rd and 5th February.
3rd and
3 p.m.
5th.
Only item number 4 and 5.
3rd and 5th February at 3 p.m. Yes.
Item number 4 and 5, my lord, the interim order was still today.
4 and 5.
Yes.
In this.
See, same group. 520 and 521.
What about the other
Till disposal.
Interim order still disposal.
This also may continue.
Yes, lordship will continue it till
The item number 3 and 4, learned counsel for the petition
4 and
submit
5.
that. 4 and 5. Okay. WPO 520 of 2024 and 521 20.
Yes.
Counsel for the petition raised for extension of the interim order. This court find that the other petitioners are already enjoying the interim order till the disposal of the application. That the interim order is extended till the disposal of the.
All right.